I'd like to welcome everyone to our SRCAR legal panel and town hall. If I'm not mistaken, I think this might be the first legal panel that we've done at the association. And the benefit to everybody on right now is it's being brought to you at Curtis the Boss Doss's favorite price. Your admittance was free 99, so you should be very appreciative of that. Just kind of set a couple of things up for the day. First off, and I know a lot of people are coming in, today happens to be Daniel Brinkat's 15-year anniversary with the association. So if you could just quickly help me, recognize Daniel and all he does for our association. 15 years is tremendous. Daniel, congratulations, and thank you so much for all you do. Let's set the tone a little bit for what's going to happen today. We've got about 3 hours to get through a lot of information, and our goal is going to be to answer as many questions of our members here as possible. We've got quite a few topics. Obviously, you've seen our flyer. We've got fair housing, CRMLS issues, forms, some standard of practice, hate speech. So there'll be lots covered. We're going to have all of our panelists do about a 20-minute presentation or so. And then after that, we're going to open it up to questions. So I'll help moderate those through. Hopefully by now, everyone is comfortable and familiar with Zoom. If you're not, for whatever reason, at the very bottom of your screen, there is a reaction button. And then there's where you can raise your hand when it comes time to get to questions. I will give a disclaimer, as I'm sure John or maybe our panelists will as well in the future, but they're not giving any legal advice. This is general questions, general education, but we want to get as much information out to everybody here as possible. So I'm going to take a couple of quick seconds and just introduce our panel speakers that we've got going on today. They've got very long and impressive bios, so I just cut a little bit out for each one so you know who we've got. So our first speaker today will be Branden Butler, who is the Assistant Deputy Director of Education and Outreach for the California Department of Employment and Housing. Branden Butler, as I said, is the Assistant Deputy Director. Prior to joining DFEH in 2019, Branden was the Senior Attorney of the Fair Housing Center of the Legal Aid Society of San Diego, Inc., LASSD, where for 9 years he was instrumental in creating the first fair housing services program at LASSD that provides education, outreach, testing, and enforcement of fair housing laws. And you all know how important and how much of a discussion fair housing is lately, so really looking forward to Branden's presentation. Once Branden wraps up, we're going to bring on Jeff Smetana from CRMLS. Jeff has been practicing real estate and business litigator and trial attorney since 2014. Representing realtor and homeowner associations, as well as brokers, serving with private law firms and the city attorney's office for Corona. Prior to his legal career, Jeff was a real estate sales and loan agent for 12 years, has a decade of experience in construction as a former building contractor, and is taught as an adjunct professor of real estate law at Cal Baptist University in Riverside. At CRMLS, Jeff oversees the compliance and data licensing departments and provides in-house legal counsel. And our final presenter doesn't really need much of an introduction. I think everyone here knows John G. We've been blessed to have him on board as well. But in case you haven't had the opportunity to meet or hear from John G., John Giardinelli is a principal and founding attorney of the Giardinelli Group, APC. He currently serves as of counsel to Tyler & Bursch, LLP, and was admitted to the state bar in let's just say a while ago. I don't want to age him at all, but it's been a while. John honed his skills on transaction and litigation in real estate business and general litigation. Currently, his practice is focusing on real estate and business law. He represents 8 realtor associations, including ours, with membership exceeding 35,000 realtors. He regularly lectures on real estate, trains and oversees professional standards for several realtor associations, and is always a wealth of knowledge. We appreciate having everybody here. So with that, I think we want to get going right away. So Branden, I'm going to go ahead and turn this over to you, and feel free to share your screen if you've got some information. Quick reminder to everyone as you're coming in, if you could just please keep yourself on mute so we can eliminate as much background noise as possible. And again, we will get to Q&A at the end of all 3 presentations. Branden, the floor is yours.
Okay, well, good morning, and it is always a pleasure to connect with the association. I want to thank John and Adam for inviting me and inviting the department and really facilitating a great collaboration with you, our stakeholders, because it's critical for us to communicate with folks, in the real estate market about fair housing principles. And I'll just announce that we've really been working closely with the Department of Real Estate terms of upgrading the exam, in terms of, just train their enforcement staff. So we are working more closely together and hopefully providing more information and resources to you. So with that, let's jump into it. I wanted to get into fair housing, cover some of the hot topics, as well as give a little bit of an overview, because I think we always gotta go there. But as Adam said, this is not for informational purposes only, doesn't establish any substantive policy or rights, and does not constitute legal advice. So there's our disclaimer. Now, most of you probably already know, so I won't spend a lot of time here, but we are California's civil rights agency. You primarily know us because we enforce housing discrimination laws and protect Californians from discrimination, but we also do employment, which can come up within the real estate industry, of course, discrimination within a brokerage office, for example. But we also cover business discrimination, right? If any business is discriminating against the public, that will also is on our jurisdiction, as well as for the perpetration of acts of hate violence, which unfortunately, with COVID-19, we have seen a bias-motivated violence against our Asian community members, and that's certainly abhorrent, and we do have jurisdiction there, as well as jurisdiction in human trafficking on the civil side. But just a little bit about us. But I thought I would jump in just to, we're talking about fair housing, and I think when we talk about fair housing, we always have to go back to our history. Now, we've had a federal Fair Housing Act since 1968, right? It was passed 2 days after the assassination of Dr. Martin Luther King. But in California, we have a different history. We started in 1959 with the Unruh Civil Rights Act, which was this first law that protected against housing discrimination. It was somewhat narrow. And then in 1963, we, Senator Rumford, who was the state legislature, passed our first Fair Housing Act. It was called the Rumford Fair Housing Act, as it was nicknamed. And so we actually have had a state fair housing law before the Federal Fair Housing Act by several years. But as you may know, the following year, there was one of those dreaded propositions in California where essentially Proposition 14 was put to the public to say, should we overturn the Rumford Fair Housing Act and allow private discrimination in the rental housing or housing industry? And it passed overwhelmingly 2-1 to allow discrimination in California. Ultimately, it was ruled unconstitutional by our Supreme Court. But I just had a little picture here to show you of people at the Los Angeles Library in 1964 who were, you see folks in the front saying, protect civil liberties, abolish the Rumford forced housing, which was the fair housing law. Then you see a great many people on the other side advocating for fair housing. So I think when we have these conversations, it's always important to remember, where did we come from? How did we get here? And part of our story in California is we voted to allow housing discrimination. Luckily, it was overturned by the courts and we've moved forward. But just a little bit of our own history. And I think to get to even more history and why we're here today, why do we even talk about fair housing, right? Not only do we have that past, but we can go further back to look at the history of the government's involvement in creating segregated and discriminatory housing practices. And here you're looking at the original map from the Homeowners Loan Corporation, which was a quasi-governmental operation created after the Great Depression to go around to all of the major cities in the United States and rate the property to determine whether there could be investments or homes could be insured. Here's where you get the redlining type discussion. But here's the map that was done in the late 1930s, early 40s of San Diego. And what you see here is the red was considered the hazardous area, where the map maker said, certainly don't want to invest. Yellow was, hazardous, going down. Blue was okay, transitioning, and green was your best. And so I just show you that this was the original map, and behind the map there was always some notes from the makers here, and one of them, talking about the kind of green area that you see north of Balboa Park there. It says canyons considered very desirable for home sites, residents white, with a few of the upper class Spanish families consisting of naval officers, business and professional men and retired people, no ratio of concentration, no threat of infiltration, restricted to the Caucasian race. And contrast that with the area that was considered actually in the blue. I was going to point to you like you could see it, but it's near Coronado, and it says this area lies along the bay and is a desirable district. However, in this area is located the servants' quarters for the colored population of Coronado. There's considerable building going on at this time, and were not for the colored population and a dump at the northeast portion of the area, the same would be blue and comparable with the other areas. It's absolutely desirable with the exception of the facts that set out above, and it's necessary for this exclusive city to have such an area. And so I like to just, pose that as we think about fair housing. This is our history. We had restrictive covenants. We had laws banning where folks could live based on race. And you're looking at a map I pulled of San Diego, and the orange dots represent the Caucasian population, the blue, purple, and green represent the Latino, African-American, and Asian communities. And you'll see, if you look at this, where the concentration is, and I might even be able to pull up my nifty laser pen here, you'll see here, this is the same area that was red in the map you saw. So, 60, 70 years later, the area where folks were concentrated based on race, and also this map is showing you poverty levels. The darker is the higher income, the lighter, lower income. You see here the concentration of people of color with the lowest poverty in the same area 60 years later. So we still have a long way to go. And here's that same map just showing you where the affordable housing is, which is concentrated in the area that is mostly segregated historically. So we have a long way to go with fair housing. Again, when we talk about fair housing in California, remember, we're talking about someone doing an adverse action because of a protected basis. These are the protected bases in California. We have many more than the 7 federal laws. I will have you note, though, that in California, we've always protected sexual orientation, gender identity, and gender expression, or at least very recently. You'll note that HUD in the last month has declared that they will view, sexual orientation, gender identity, and gender expression within the broader subset of sex discrimination, sex-based discrimination. This is a reflection of the Supreme Court case that ruled that that Title VII, employment law did protect, these other areas of gender. So you're seeing the federal government kind of get more in line with the state now, which is a good thing. So these are protected bases. We don't have time to run through them all, but we have many, and including, and this is where California law gets a little maybe tricky for folks, is we have the Fair Employment and Housing Act, but you also have to know that the Unruh Civil Rights Act also is in play when we talk about fair housing. And under the Unruh Civil Rights Act, it also provides protections for primary language discrimination. For example, I'd rather not rent to somebody who can't speak English, we can't communicate. That would be primary language discrimination. Immigration status, that's unlawful. Unless it's some type of federal requirement, we're not getting into immigration status or asking about it. Age is also protected, as well as citizenship status. So these represent, on these 2 slides, the protected bases in California. If it's not on this list, then it's not a generally protected basis. Although we do have arbitrary discrimination, but I'll save that for another day. We've recently released our 2019 numbers on the complaints we received. I know it's 2019, but we only had these up over the last, it came up about 6 weeks ago. And you'll see that disability represents our highest level of complaint, as it usually does every year. We had 934 housing discrimination cases filed with our office in 2019. You'll see, but you're saying, well, what's the 1,500 bases? Well, that's because folks may say they were discriminated against on multiple protected bases. It was race and gender. It was religion, right? So you could see how the number will be more, but we received 934 filings in 2019. Now, and I'm just kind of giving you highlights and just kind of brushing through. One thing that I think I always have to let folks know is in 2020, the department, through our Fair Employment and Housing Council, which is appointed by the governor and promulgates regulations, released our fair housing regulations. They were the first time ever done. I think we're one of the first states in the country to do this. And these are the an overview of the regulations that are covered. We don't have time to cover all of them. They're very in-depth, but I would encourage everyone here to actually take a look at them and read them, because they do provide substantive discussion on what is discrimination within financial assistance with real estate, or real estate practices, or land use practices. really gets very deep in there. So we do have these regulations overview. I'm going to touch upon a few highlights though right now. So they became effective January 1st, 2020. You can find them in our California Code of Regulations. Here's the site example I'm just running through. But one thing I wanted to highlight in terms of definitions that I just swiped that I thought is interesting for all realtors is in the regulations, in order to have standing to bring a fair housing case, we need an aggrieved person, right? Someone has to have actually been damaged to bring a case. And an aggrieved person under the regs includes any person who believes they have been injured by a discriminatory housing practice or believes they will be injured by a discriminatory housing practice that is about to occur. And I point this out because many times I don't know if realtors realize that y'all have standing if you're being discriminated against, your client is, right? You're aggrieved. If you're trying to close a deal and you hear from the seller, they don't want to sell the house to your client because of their race, their religion, and now you can't close the deal and you're out, substantial money, you've been aggrieved because of this discriminatory housing practice on part of the seller. And so just pointing out that, and we do get calls from realtors about this, that you are aggrieved if your client is facing discrimination, or maybe you yourself have faced discrimination. Someone doesn't want to close the deal because they're concerned about they don't want to work with the realtor because of their race, the seller, or other protected bases. So just pointing out that realtors have a lot of skin in the game in terms of trying to fight discrimination and can personally bring a case. All right, let's jump into some more highlights. First thing, that if you're not aware of it, the regulations spend a lot of time talking about discriminatory effect. Some folks may know this as discriminatory impact, but discriminatory effect is a theory of fair housing liability, saying there was no intent to discriminate, no intent. We love everyone. But the impact of your policy or practice is that it's creating a disparate impact on a distinct group of people that's creating, enforcing, or reinforcing discrimination or segregated housing patterns. So it's this broad idea, and I bring this up because you'll see where I'm going with this, but I want folks to know that when we think about housing discrimination, we're often thinking about intentional discrimination. They won't sell the house to me because of my race. They don't want people here with families with children. But discriminatory effect just says, no, everyone's welcome. It's just that my policy is I require a buyer love letter before you move in here. That's it. Now, one will wonder, is that having a discriminatory effect? Perhaps someone who doesn't get a home, if someone were to run a statistical analysis, if certain folks of one race never get the property when they turn in a letter with a picture, someone may wonder, is that having a disparate impact? And there is a test for this. There is a burden shifting argument. But basically, the person who's doing the practice, like for example, a buyer love letter practice, where the buyer has to send us a letter to the seller with pictures of why they want the property, you can do these things so long as it has a legally sufficient justification. So it's necessary to achieve one or more substantial, legitimate, non-discriminatory business interests. I'm not sure if it does, but that's one thought. The practice effectively carries out the identified interest, and there's no feasible alternative practice that would equally or better accomplish the business interest with less discriminatory effect. So this is the test because you're going to hear it in the news, you're hearing it a lot in society, that it's not just intentional discrimination. It's this, unconscious discrimination that's having an impact. And there's a lesser discriminatory way to achieve the business interest goal. So the regs spend a lot of time on this, and I would encourage you to look at this. But in terms of buyer love letters, because I know this has been kind of a hot topic, and again, I'm not giving an official opinion on this, but just to talk about it. I went and pulled up from the National Association of Realtors, their website on buyer love letters. And basically, this is from their article on their website. And it says, buyer love letters are a tactic used by some buyers in an attempt to stand out to a seller, especially in hot markets with low inventory and bidding wars. Seemingly harmless, these letters actually raise fair housing concerns and can open real estate professionals and their clients to violations. And then so to entice sellers to choose their offer, buyers sometimes write love letters, describe many reasons why the seller should pick them. You all know what this is. And you can understand where the risk comes in, where if there's pictures and things coming in, perhaps it encourages intentional discrimination, or perhaps there's some kind of unconscious impact that's being happened where folks who are maybe not white or are not getting the property. Now you could change that out with different protected bases, but I'm just raising these issues as to how they can both come up in intentional discrimination as well as an impact. And I just thought this was interesting to talk about. Maybe, folks may be familiar with the blind orchestra auditions. You know, this has been a big topic on the employment side. And basically what happened is in orchestras throughout the United States, they were predominantly all men. And men were, you know, made up most of the chairs in an orchestra. Well, orchestras started to get concerned about the broad kind of just, you know, sex-based discrimination that was occurring. And they went ahead and started doing blind auditions where literally they put a screen up, you would audition behind a screen, no one would see you. And in fact, they would actually tell women to take off any heels, walk barefoot, but no one could understand if they could, what gender it would be. And as soon as they did that, and you just did the blind test, the amount of women who were in the nation's top orchestras dramatically increased. And you know, from 6% to 21%. Again, given that there's very low turnover in an orchestra, you know, people say that for 50 years, I mean, that's huge. So I just bring this up when you think about buyer love letters, think about this, think about how we saw discrimination go down when we did this different way of doing auditions for orchestras, and compare that with the buyer love letter. Now, I'm not saying that buyer love letters are in and of its face discriminatory, but I'm just raising these issues to help you think about how do we achieve a society that has less discrimination, and perhaps, you know, removing things that could influence people unconsciously is an issue to think about. So I just bring that up. Now, real quick, just to run through intentional discrimination. You know, when we talk about protected real estate transactions and fair housing, we're usually talking about these major markets: rental housing, sales, insurance, lending, and appraisal. If you're treating anyone differently in those contexts because of their protected bases, intentionally, it's going to be discriminatory, right? And, you know, examples we have are steering, block busting. This is where you would, you know, encourage people to sell their house because people of another race or ethnicity are coming for a profit. Then we have the issues of appraisal, of lowballing folks of protected bases on lower than their home is worth. So we've seen a lot of these things in the news lately. Now, I know we've talked about it here, and I was hoping just to show 1 minute of this clip in case folks have not seen it. But the Fair Housing Justice Center in New York did the Long Island Divided news investigative story where they essentially tested real estate agents for discrimination in Long Island to see whether or not there was discrimination occurring. New York is a one-party consent state. So in this study, everything was recorded. It's not the case in California. We cannot record without consent. But here in this study, over 2 years, they conducted a whole bunch of tests and essentially found that there was discrimination occurring among potential Black buyers and Hispanic buyers and Asian buyers to a lesser extent. And I want to quickly just show a 1 minute clip of intentional discrimination, just in case folks have not seen the Newsday study. So I'm going to go ahead and do my Zoom DJ real quick, where I'm going to stop the share. And I'm going to show you this clip. So just 1 second. Make things big. Okay, here we go. So just 1 minute clip, and it just is a test between a Black prospective homebuyer and a white prospective homebuyer. And let's see if you can spot where the problem is.
About that. I have to get used to about that because I've been running like a dog.
I know. So I really need that. I won't take out anyone unless you have a pre-qualification letter. So I need to know that you're pre-qualified for a mortgage.
Oh, so that means I can't go out to see anything.
I won't do it. You can try another person, but I don't have the time to do that.
Oh, good. I'm just going to take some notes and introduce you to signature.
What is your availability? When can you start looking at houses?
I would say not this coming week, but the following week.
Okay. So today is, let's set up our first appointment. I will send you listings this afternoon.
Now, if you haven't seen this study, I know many have here, but you really should watch this because I think it really shows you how subtle discrimination can be, how the issues pop up. But this one is just a great example of potential discrimination. You told the Black prospective home buyer they needed a pre-qualification letter. Did not tell that to the white prospective home buyer, who both had the same criteria and wanted to live in the same area. So it goes through many examples, but I just bring this up to say discrimination is still with us. And what this study shows us is that it's more subtle. It's hard to detect. That was a very obvious example, but others are more subtle. And so I would just encourage folks to watch this and know that this has changed the industry, and folks are taking a harder look at how we engage in the real estate practice based on this. Another hot topic has been appraisals for Black homeowners. Been a couple of stories in the New York Times, one as recently as 2 weeks ago. But the gist of the stories has been, and here's one of the couples in the story, where when they originally had their home appraised, it came in much lower than when the African-American wife took all of her pictures down, removed any semblance that she ever lived there, and put up pictures of her husband's family everywhere. Home appraised for much higher, much higher. And this is something that's been very common in the Black community. And another story I point out in the same article was the comedian D.L. Hughley, who had a similar situation where he bought a home in West Hills in Los Angeles, put in a pool and new hardwood floors, and had it appraised, and it came in at the same amount he bought it for 3 years later. And then they said that was odd, and the bank flagged it and thought that the property was in disrepair. And as the comedian says, they were like, this has to be some kind of mistake, because in order for your house to have come in this low, it would have to have been in some level of disrepair. The bank ordered a new appraisal, which came back for $160,000 higher, and he went on to sell his home for $770,000. This was, a long time ago in the 2000s, but pointing out that no matter who you are, it still seems that there's been an impact where homes are appraised less, and not in every case, but there's been more of this coming out. And so I just point this out, that this is a hot button issue and something to be aware of, making sure people are getting training and not imparting any bias when they do a appraisal. Another highlight I want to mention, and we're going to be releasing hopefully at the beginning of April, a manual on harassment in terms of what should HOAs be doing, what should realtors be doing in terms of harassment in the real estate context, either between against the client, or if it's a landlord against the tenant, or if it's two tenants against the tenant. We're going through the whole deal and giving really clear guidance on what type of investigation needs to be done to ensure that there is not harassment, or to make some action against the harasser. But one of the highlights we're going to be getting into in the document is, what do you do when another tenant is harassing another tenant? And I bring this up because many times in my experience, realtors are engaging in property management. And you need to know that the owner of the property can be liable for the actions of a third party where they knew or should have known of the discrimination and didn't take any actions to correct it or end it, right? So if there's someone in the HOA who's being harassed based on their gender, and you say, well, it's not our problem, call the police, figure it out. Actually, it will be your problem, because you have, not only is there this liability factor, but you have the ability in the HOAs and the CC&Rs rather to, perhaps find the person, perhaps they're removed from the property. You may be able to take an action that you have the ability to take if you do. Usually that authority comes from the CC&Rs or a lease agreement. So just pointing out, that's one of the topics we're going to get into. A few words about liability in the regulations, right? We have direct liability, which is failure to take action or correct a discriminatory practice by an employee or agent or a third party, right? So your clients can be held liable for this. And we also have vicarious liability, right, where the owner of the property is liable for the employee or the agent's conduct, regardless of knowledge, even if it was willful or malicious or disregards the employer's express order. So just a great point, for when you're a realtor and you're representing someone. If you have a client who's saying do something unlawful, it's going to go all the way up. Not only to you, you're going to be held liable. Everyone's going to be liable. So it's not like it's just them. You are acting on behalf. It's vicarious liability flowing both ways. So watch for that. Now, one other note I wanted to mention, it's not really a fair housing issue. Well, it can be, but I wanted to represent for the real estate industry is that we have authority at DFVH to enforce Civil Code 51.9. And it really gets to harassment in the real estate industry, right? Within realtors and brokers and loan officers. Because what it basically is saying is, you know, you can be liable for sexual harassment if there is a business, service, or professional relationship between the plaintiff and the defendant, and there is harassment that occurs in there. And these relationships can be attorney, it can be real estate appraiser, investor, accountant, banker. These may not be your employees, but you have a professional relationship with them. And I know this is very common in the real estate industry among other realtors. And so just know that there is a law that really touches upon this, of where there's not a employee-employer relationship, but there is a professional relationship, and there's harassment occurring between that. You can be held liable. So I just want to point that out, that there is this authority, and our office is enforcing this civil code. And we have done one of our first cases on it involving a stockholder a situation where there was harassment. So just pointing out, it's the non-traditional, not employee-employer sexual harassment is covered here. And it's not new, the law's been around, but it's just that we're enforcing. All right, the last couple of updates, and I promise I'll get out of here because I know there's so much good info. One major update, right? In California, we passed SB 329. It now prohibits discrimination on the basis of receiving a Section 8 voucher or other rental assistance. That's, you know, so it's still new. We're still seeing a lot of violations, right? So we conducted a survey of all of Zillow and Craigslist, and we basically sent out hundreds of compliance letters to housing providers, realtors, folks who were listing discriminatory advertisements that we found. And, you know, we found 416 discriminatory ads just doing a spot check around the state. And we opened 176 cases. We sent out these letters. Many were to realtors, and they did not know the law, and, you know, we're engaging in property management. So I just want to make sure everyone is aware. We gave everyone kind of a warning, but it is now going to go, you know, move more towards enforcement. So, you know, do know that it is unlawful to state you will not accept Section 8. You have to treat everyone the same. We have guidance on this that you can look into, but want to just lift that point up because we did see a high level of realtors involved in listing these discriminatory advertisements, saying no Section 8, right? That's unlawful. And I'll just make a note too, with all of the COVID-19 and rental assistance stuff going on, again, you want to be very careful here if you're doing property management, because some forms of rental assistance, you know, may trigger source of income issues, right? Because source of income is not just Section 8 vouchers, it's any form of rental assistance, federal, state, or local. So it's fairly broad. And again, as I stated here, it's federal, state, local. And, you know, it includes all kinds of, you know, vouchers and kind of everything you could imagine in this area is covered. So tread lightly when looking at this. Treat everyone the same. Folks still have to qualify, and we only look to the actual rent that the individual pays when we qualify them. Meaning we don't say you have to make 3 times the rent's $3,000. Do you have $9,000? If the Section 8 tenant is only paying $200, we're only looking at, do you make 3 times $200? So we don't look at the contract rent, we look to how much does that individual pay. And everyone has to comply, HOAs included. Lastly, just to get out, another major kind of hot topic is prohibited uses of criminal history information in housing. It's a broad subject, but just to give you the take homes, one is, you know, is that you can have intentional discrimination, right? Like saying, for instance, I saw a story in the Kelly Richardson, who does a lot of the HOA stuff, had a piece a couple of weeks ago in the paper about an HOA who was wanting to run a criminal background check on a prospective buyer. And while one can run a criminal background check, it has to be very narrowly contoured. We cannot blanket ban everyone who's ever had a conviction. It's going to violate fair housing laws. Not that because someone with a criminal history has a protected class, but it is being seen as race discrimination because of that theory I talked about earlier, disparate impact. So some of the take homes are, you know, we should never be using certain criminal history information. Arrests shouldn't be used, infractions, if you've been in a diversion program, none of this should be looked at by an HOA or a landlord. any conviction that's been sealed or it's been a juvenile record. These are all off limits, cannot be considered. And if one is going to do a housing screening process where they look at criminal history, you really have to make sure that you're looking at whether the specific crime is a demonstrable risk to the other residents or the property based on evidence. So is the criminal conviction directly related to safety? What's the nature and severity of the crime? How much time has passed? Again, what's a directly related conviction? It means a criminal conviction has a direct and specific negative bearing on the interest of the housing provider. So for example, a 10-year-old misdemeanor conviction for a driving offense is not directly related to paying the rent and fulfilling your obligation to being a tenant, as opposed to a recent conviction for residential arson, right? That would be directly related. You were just convicted of burning down the property. That can go to the safety of my property or the other residents or my employees. So lots more there in the regs, and we have resources for you. And as well as we have an updated employment or housing complaint flow chart where you can understand how complaints work at DFEH, what's happening. So we've updated it just to make clear here too. Folks file a complaint, we do an intake, and right here, and this is where I think we want to clear the confusion up. There may be a complaint sent to you at this stage where it says, does DFEH have jurisdiction? Does not mean we've investigated the case. Does not mean we've made a finding, just that we have jurisdiction. So if you do get a DFEH complaint, do go through the process with us. There is an opportunity for mediation. And it doesn't mean that we've made a finding just because a complaint has been served on you, okay? And then lastly, we've launched our Keep California Fair campaign. So you can look, you might be hearing radio commercials, seeing billboards on this. And then we have a great many FAQ and fact sheets for you. And I would encourage you to read them if you're doing property management for sure. Take a look at this, but even in the sales context, I've seen it with HOAs and condos of running background checks or disability-based discrimination against the home buyer. So you want to really check in because these issues do really relate in those contexts. So I'm going to stop talking here and get out, and hopefully I've kept your time, but I really appreciate being here and always a pleasure to connect with you. And if I can ever be a resource, feel free to reach out, and I look forward to your questions later. So thank you, and I will stop sharing now. Let me just.
Thank you, Branden. Obviously, this is a topic that we could probably spend hours and hours just on this alone. And I think you pointed out it's not new. It's kind of popular and a hot topic right now, but it's nothing new. It's just being brought a little bit more aware. I will mention real quick before we go on to our next speaker, some of the comments you made, about the inadvertent discrimination. There's also known as implicit bias, and there's actually a legislation right now that's being put forward that would require implicit bias training as part of the continuing education for every real estate agent to go through. And that has passed out of committee. So I wouldn't be surprised if we saw that being added to some of the education and training requirements moving forward. Yeah. Something else, just so you know, and I would hope it doesn't come to this, but when you're talking about those love letters, and John has talked on love letters before, and maybe he'll touch on those again today. But it's all kind of that unintentional discrimination that could come from that. I actually had an agent friend of mine from another area said there's been a lot of discussion in their area about removing buyers' names on the offer so as not to potentially, have some sort of discrimination, which seems extreme, but you just don't know where things are going. So definitely some interesting times there on that as well. Anyone that may not have joined us right away, welcome to our group here. We are going to get through all 3 presentations. We've got 2 more to go before we open it up for questions. So I do see some questions going on in chat. Feel free to just hold on to those. We will have time for that. And then all of these topics, but fair housing is in particular, tends to sometimes raise some uncomfortable questions. And I think and I would hope that everyone here is a professional. And feel free to ask some of these uncomfortable questions. There should be no judgment. We want to get the information out as much as possible. So please treat this as an open forum and one of respect. And as these questions come in that we aren't normal, probably go-to conversations, I think this is an opportunity that we can hear directly from sources that have those proper answers. So I just wanted to throw that out there and have everyone please keep that in mind. So Branden, thank you again for your presentation. And I'm sure there'll be some questions here shortly coming your way.
Yeah, looking forward. Thank you.
Thanks again. So our next speaker is Jeff Smetana from CRMLS. There's a lot going on with CRMLS. I'm sure he's probably going to touch on some of the coming soon issues and concerns that have been out there. But without further ado, Jeff, if you are ready to go, I believe you are unmuted and you should have full function to share your screen if necessary.
Okay, well, thanks, Adam. Good morning, everybody. Thank you for having me. I always appreciate it when John allows me to join in with him, and I learned a lot from all the speakers, and I just really learned a lot from Branden. That was great. I think we all share a sense of frustration and or sort of disappointment with the fact that some of these things are still ongoing, but I think we're all definitely working towards, taking those fair housing concerns very seriously. So thank you for that. From our perspective here at the MLS, it is a very interesting time that we are living in. I will start off with a litigation update. Now, that might seem like, oh, this is all going to be lawyery stuff about cases and whatnot, but these are real cases that are affecting us, and by virtue of that will affect you in your practice. There's been a lot of cases filed over the last couple of years that do involve a lot of the issues that we're concerned about. Starting at the national level, you guys may be aware that in November, the U.S. Department of Justice filed a lawsuit against the National Association of Realtors. That is never good news when the Department of Justice comes knocking at your door with an envelope. In this particular case, at the same time that the lawsuit was filed, there was a settlement agreement filed, which tells us that NAR was already talking to the Department of Justice about the issues involved in the lawsuit. So coinciding with the lawsuit, a settlement agreement. What was in that settlement agreement? Well, I'm going to tell you about some of those things. Most of it is really issues that the DOJ is concerned about regarding consumer protection, which is a very broad term, but really related to some transparency regarding commissions and who's getting paid and what's being paid and things like that. But what has happened now after the settlement has been filed is there's a period of time where NAR has to promulgate some rules. They have to take the settlement agreement, the agreements that are itemized in there, and come up with some proposed rules that they can then put into their model rules and make those mandatory for all of the NAR affiliated MLSs and associations. At this point, we're still waiting for those rules. So if you are familiar with this lawsuit and you're familiar with the issues I'm going to talk about, know that these are not necessarily rules yet. Okay, I've had a lot of responses and engagements with people who say, well, you need to do this right now, and I need to change my behavior right now, and these kind of things. Well, it's good that you're thinking, with foresight, but at this moment, we're still waiting on these. There's a period of time where NAR has to create these rules, and then they have to talk it through with the DOJ, and then ultimately the court has to approve, the final settlement agreement, and we go from there. When will these be done? Well, we're not really sure. The settlement agreement does say that once the rules are approved, there's a 60-day period after that, and then they become official. That has sort of hit a timing delay. And the reason is because as you well know, we recently had an administration change in the White House. And the DOJ being subject to White House governance, there's been a change of staff at the higher levels. And a lot of the folks who were involved in developing this lawsuit and this settlement agreement have moved on, whether by their choice or not. And so now we're waiting for some people to grab the steering wheel on this. And until that happens, this is sort of in limbo, but we are prepared to, work with NAR and absorb whatever it is they send to us and implement those things directly. So take a breath. What I'm going to talk about is not necessarily a reality for you yet, although there are some things that we at CRMLS are working on proactively that I'll tell you about. So the 4 things in the settlement agreement. The first one is really regarding transparency regarding commissions, compensation, specifically buyer's office compensation. The DOJ is concerned that consumers might not have a great understanding of this. And so they cut to the chase on this fairly quickly, or fairly straightforward, and said basically buyer's agent compensation, which has heretofore been a confidential field in the MLS, is now something that's going to be public facing. So for us at the MLS, for our public facing aspect is known as HomeSnap. That means that the listings that we send to that public facing site are going to include buyer's agent's compensation as a percentage in there. We are also required to provide to you, brokers and agents, and those of you who have your own websites, the buyer's agent's compensation in the IDX, Internet Data Exchange feed. That means you can choose to put that field public facing on your websites for folks to look at and understand. Now, we're required to send it to you, but you're not necessarily required to display it. You simply now will have the option to. I will tell you that we've already done this. We have already included in our IDX payload buyer's agent's compensation. So if you're a broker out there and you want to get a jump on this, you can certainly start displaying that. We can't forbid you from doing it, but again, we can't make you. So really that's the first point. Basically, buyer's agent's compensation will be public facing, and we are not allowed to hide it in any sense. It is no longer a confidential field. The second item, the DOJ is concerned about steering, and this is not necessarily steering in the context of what Branden was talking about, but it has more to do with compensation. So what they're saying is, we want to keep an eye out and make sure that people aren't steering folks to listings that only are offering a certain compensation. Okay, I'm certain that none of you think about this or do this, but what the reality is they want to make sure that doesn't happen. We at CRMLS, when we became aware of this, we went into our database and our records, historical records, and found that virtually no one is searching listings by compensation amount. We have a record of every single search that's ever been done, and it's not really a real thing for us. Nonetheless, what the DOJ has said is, you're not going to be able to search by compensation anymore. We don't want that to even be a possibility. So here at CRMLS, we've removed that potentiality, that function for you to search by compensation in accordance with what the DOJ is concerned about in this settlement agreement has been removed. The other thing is, and this is something that we're not sure is appropriate, is they also are concerned about steering based upon listing office. So they've asked that we also limit the search capabilities or remove the search capabilities for you to search by agent or broker. Now, in one sense, it makes a little bit of sense, because perhaps there are brokerages out there who are known for offering a very low or non-existent compensation amount. There are discount brokerages out there. DOJ is sort of saying, well, we don't want you to even be able to look for those folks so that you can exclude their listings from your searches. However, I think we all know that there's a lot of reasons to search by agent or brokerage that are unrelated to compensation issues. And recognize that these rules that they're putting forward, or their proposed rules, apply to AOR staff and MLS staff. And here in the compliance department, we have to do a lot of searching by agent and brokerage. We have to find out, what their historical records are, and for a lot of our investigations, or the AOR might need to do something on their end for their concerns. Or you might want to see how many deals has this person that I'm potentially dealing with done in the past. Again, things that have nothing to do with compensation. So they're asking us to limit that search functionality. Our hope is that NAR might push back a little bit on that particular aspect here. Once the rules come out, perhaps there's going to be a period of public comment or debate. It would be great if we can join in on that and maybe open that up to a little bit more discussion. The third thing is more of a code of ethics issue. It doesn't necessarily implicate the MLS, but it's good for you guys to know about. And what the DOJ is asking is that agents and brokers are no longer allowed to advertise their services in representing buyers as being free. Okay, and John can speak more directly to this, but I know that one of the standards of practice in Article 12 of the Code of Ethics allows that for all intents and purposes. But I think we all understand that this can be a little bit of a debate. In other words, who really is paying for the buyer's agent's compensation? I think that the prevailing view regarding this point is that at the close of escrow, the money is coming from the buyer's side, right? It's coming, the buyer's bringing the check, or the buyer's lender is wiring the funds to close that transaction. And out of those particular funds, the buyer's agent is being compensated. So based upon that logic, that reasoning, the DOJ being concerned about a misrepresentation of the reality of how this works is saying, hey, let's do away with this. It's bordering on perhaps dishonesty or not really, appropriate disclosure on how these folks, these buyers, are paying their agents. All right, so that's the third one. The fourth one is a little bit of a technical issue, and this has to do with lockboxes. What the DOJ has asked is that a non-NAR member, agent or broker, be provided access to the lockboxes on the listings. At this point in time, that's not how it works, but it's going to happen that way. And what it'll probably look like, guys, before we get into too much of the technical aspects of it, and your questions go down that road, is the vendors that we use and that you probably use out there have the ability to produce a one-time use code. So we're not talking about someone who just gets to go anytime that they'd like, based upon having unlimited access to all lockboxes. It would still be something where access is controlled by the listing agent as determined by the seller. Okay, so if someone calls up and says, hey, I'm not an MLS agent, I'd love to see this home, your seller is the one who decides if that's going to be okay, and you can work with your lockbox company to provide that agent a one-time use code. So we're going to work out all the technical details of that is in an ongoing sense. So that's the NAR level stuff that's happening. Now, there are some other things out there on a national level involving NAR, involving commissions and compensation that are pretty broad. There are class action suits in the Midwest where the gist of the argument is, hey, I, as a seller, am paying too much. I was forced to pay too much in compensation because there's standard amounts of compensation that everybody expects to be paid. So that's the gist of that lawsuit. It is moving slowly. There's another one that's on the buyer side, okay, related to some of the topics I just talked about. I won't go too far into the weeds on those. Those are large. They involve NAR. They also involve some of the larger real estate companies in the country, as well as some MLSs, but thankfully not CRMLS. Closer to home, we do have a lawsuit that has been filed in federal court against NAR and CRMLS and two other large MLSs. Now, this lawsuit was filed by a company in the Northern California area called the Private Listing Service, the PLS. And the PLS is, for all intents and purposes, under any legal definition, a competing multiple listing service that is non-NAR affiliated. So they would take in listings from anybody and push them out in a very similar manner as we do. What this lawsuit involved was antitrust claims. The PLS alleged that NAR and CRMLS and a couple of other large MLSs in the country came together to produce the clear cooperation policy. So that's at the heart of this particular lawsuit, is the CCP. And what PLS's argument is look, because of the CCP, as you guys know, or you should very well know, which requires you to put your listings in the MLS within 1 day of public marketing. So you can still exclude your listings, but if you market them publicly, you have to put them in. What PLS is arguing is, hey, that hurts our business and that hurts the consumers out there. Well, recently, a few months back, NAR and the rest of us filed motions to dismiss. on several legal bases. But the good news in this lawsuit is the court agreed with us. The court agreed that the claims that PLS was making were unsupportable and had no legal basis. And therefore, the court granted the motions to dismiss, and they did something very unusual. They actually said, we are dismissing this with prejudice. If you're not familiar with what that means, it means we don't think you can even fix this. We don't think you can amend your complaint to come up with strong enough arguments or fix your weak or lacking arguments enough to survive this lawsuit or to prevail in this lawsuit. So they said, you don't even get a chance to amend. You're done and you can't come back. The court was very favorable and came out with some really great language in support of a clear cooperation policy, basically saying that everything showed that the clear cooperation policy actually helps consumers and it is consumer friendly. Now, PLS tried to make this an antitrust claim, as I said, and there's several aspects to a successful antitrust claim. One is that it harms competition, that the behavior of the defendants harms competition, and it also has to harm consumers. Okay, so it doesn't mean that just because some of your competitors do business in a way that you can't do or you don't like, doesn't mean it's automatically an antitrust claim that is supportable. It also has to harm consumers. And so the court basically said, look, we understand you might not like this PLS and it might not help your business, but it's good for consumers. Okay, there's still ways for folks to keep their listings out of the MLS if they'd like, notably via the office exclusion exception in the CCP, which means you can still sell it within your office and you're not forced to put it in the MLS. And so there are alternatives that the PLS was saying, well, we're the only alternative. And the court said, no, you're not. There's still ways for consumers to reach these goals of keeping their listings off the MLS if they really want to. So that was great news. The dark lining around the silver cloud, so to speak, is that PLS has filed an appeal. So recently, a few weeks back, they sent a notice of appeal. We don't know what the basis of the appeal will be. We suspect it will be dealing with the idea that they weren't allowed to amend their complaint. So the with prejudice issue. As I said, it's fairly unusual, but we'll see what they're actually appealing on. And that's going to be an ongoing process. So this is not done. I mean, we reached a major milestone and had a really nice success with our motions to dismiss, but that appeals at this point in the state of California and the federal level, 9th Circuit, it take 1.5 to 2 years. So stay tuned for updates. I don't think we'll have any big dramatic news on that for quite some time. So that's the overview from the courts, the things that are concerning to us here at the MLS and the aspects of those lawsuits that might affect you. So moving on really quickly, we have some rules updates. As you may know, in January and July of each year, we generally produce an updated rule set. And if there are changes to the citation policy, those will be set out at the same time as well. So in January, we sent out our new rule set. Some of the highlights. The first one is really not necessarily related to a particular rule. It's more of a citation policy change. The citation policy includes the process by which you can review or ask for a review on a citation that you might have received. So I'm sure no one on this call has ever received a citation, but if you ever do, or if you know someone who has, you do have the right within 20 days of receiving the citation to ask for a review. And it's like an appeal. And if you do that, we give you full due process. Okay, you have every right to do that. We will pull back your invoice. You don't have to pay your citation. You're not going to get suspended. We'll take the process through, and when it's done, we'll go from there. So in the past, what would happen is you would send in a review request, and we would put together all the evidence here in the compliance department and package it up and send it over to your AOR for review by the grievance committee, who would then take a look at it and decide, well, is there enough here to warrant an in-person evidentiary hearing before the Pro Standards Committee. Well, that's how it's always been. Now, with the great assistance and great work that was done by John Giardinelli, my friend and my former boss, his team in connection with a couple of the other AORs and Linda, put together something that is basically a written review. So if you think about it, a hearing is a lot of work. A lot of people have to show up in person or on a Zoom call and take time from their day and hear evidence and go through the motions on that and provide witnesses and so on and so forth. It can be pretty time consuming, and it's somewhat of an intense process, can be a little bit overwhelming if you've never done it. Not great, right? Not a lot of fun. But there has now been a streamlined process that's been introduced, and this is basically just saying, at this point now, if you want to have your citation reviewed, you can just elect for a written review. In other words, we do the same thing. We put together the documents and the evidence on your citation and we send it over to your AOR, but there's no in-person hearing. There's a panel that's put together by the AOR and they just take a look at the evidence, the written evidence. You don't produce witnesses. You don't show up at a hearing and feel all nervous and all that good stuff. The panel will just look at the written evidence and make a decision on it. The other benefit of the written review is that nothing can be added to the citation or to the case in and of itself. You should be aware that if you go with the full hearing process, the package of evidence goes to the grievance committee first. And that committee has the right to look at that and say, well, we think not only are there MLS rules violations involved here, that we see a few code of ethics violations. And so we're going to add those and then we'll send it off to a hearing. So you sort of open yourself up to greater scrutiny going the hearing process. It doesn't happen a lot or all the time, but I've certainly seen it happen where the grievance committee adds some stuff. But with the written review process, none of that can happen. The only things at issue are the MLS rule or rules that the citation was issued upon. So it's a very handy process. It is actually, the written reviews, just so you know, is the default. It is the default. So if you send in a review request, that's where it's going, to the written review. But you have the option to still select the full hearing. And there's a form that we have. It's very easy. It's online. You can check the box for a full hearing and you can go that direction. The second thing that's somewhat new is also more involved, more to the point of the procedures that we follow here in compliance. And this is something that NAR put together and has become a mandatory rule for us. And it basically says this: if you're an agent or a broker and you get your 4th citation in a calendar year, we're not going to issue you a citation. What we will do is file a disciplinary complaint. What NAR is saying is, look, if somebody is repeatedly violating the rules, there's a reason there. We want to know what's going on and we want to deal with that. So on that 4th violation, we put together a disciplinary complaint and send it to your AOR, at which time you will have a hearing before Pro Standards and your broker must attend. Okay, unless you're the broker who got the citation, you're going anyway. So it's an oversight issue. NAR has been concerned that, you know, why is this person who's practicing real estate, why are they breaking these rules so often? You know, and the logical next question is, who's in charge? Who's training this person? Who is supervising this person? Why are they continuing to sort of step in it and, you know, get hit with citations? So if you get 3 in a calendar year, that's bad enough. But if you get another one, you're going to go to a hearing and your broker is going to be involved. I will tell you that in 2020, we only had 9 people who got more than 3. I will tell you that, to my surprise, we already have a winner in 2021. Someone did manage to get their 4th and 5th violations. The pool in the office was this wouldn't happen till April or May, but this individual managed to achieve it in the 1st week of March. So unfortunate, but you know, here we go. The other thing, this is a rule issue, but it is also related to the citation policy. I talked a little bit about the clear cooperation policy. I know, I believe in my heart, you guys all know what this is, but if you don't, it's basically the pocket listings issue that was simmering for a long time. In November of 2018, NAR developed 2019, NAR developed a policy to deal with it. Because in the past, if you were an MLS user, you realize that by joining an MLS, you agree to cooperate. You agree that by joining the MLS, you're saying, I'm going to put all my listings in here so that other folks can see them and sell them. And then I get the benefit of all the other users saying the same thing to me. So the very thing that we're founded on is and the key thing that you agree to do by joining an MLS is cooperation. But there were exceptions. You know, in the past, we allowed waivers or exclusions whereby you could say, hey, I am an MLS user, but I've got a listing here that my seller doesn't want in the MLS. So here's my form. We take that, we recognize it. Okay, you guys go ahead and go about your business. And that included the ability to market that listing however you wanted. Well, with the advent of the clear cooperation policy, that last part went away. All right, you can still exclude your listings, but if you market to the public, you will trigger the clear cooperation rules that says within 1 business day of doing so, you need to put that listing in the MLS. So you can still keep them out, but you can't market them publicly. All right, so that being the case, it was a big deal, right? We started very, very early in the last year doing massive education events. I think my department and Ed and Art, I mean, I think we did over 200, you know, last year on clear cooperation alone. In May 1st last year, that rule became a reality. The policy that NAR gave us, we created Rule 7.9, put it into the rule set, and off we went. Up until not too long ago, if you were someone who got reported for a CCP violation, you would get a warning, all right? You'll need to be aware that, you know, that warning situation, well, I should say this, you were getting an inquiry and then a warning. Well, the inquiry has gone away, all right? So this second chance, third chance type stuff is no longer happening. So you got to be very, very aware that you're not going to get much chance to fix it when you have a 7.9 CCP violation. But so really, those are the highlights for our rules. Those are the highlights from the litigation world. We can certainly talk about a lot of the detailed questions I'm sure you have on compliance, but at this point, I'll wrap up my introductory comments and move it on over to John.
All right, Jeff, thanks for that. And I'm sure some questions will come in. In fact, there's a few questions in the chat that may just be simple responses. I don't know if you and Branden want to take a look at those, feel free to respond, or we can just wait till after John's presentation and go to those questions. Appreciate you touching on some of the NAR stuff as well. I know there's been some conversation about the intention of the rules versus the real life application of the rules, and you know, some of those consequences moving out. So I look forward to the question and answer section. I'm sure some will be coming your way, and thank you again for your presentation. John, if you are unmuted, we will come over to you. There you go, and let you take the floor.
I unmuted myself. Can you hear me okay?
Yes, you are good to go.
All righty. Well, first of all, I want to thank Connie Lynch. As you can tell, I am not Connie Lynch. I am in her office. The power went out not only in our office building, but in 4 others in the area that my office is in. So I was without power this morning. Connie was kind enough to let me come into the association office and use her camera and her computer. So that's why half of my head is being cut off, because I'm not going to try to fix it. We all know that Gene Wunderlich is in the process of retiring, which is going to be a sad day for all of us, and that Adam is taking over. Anyone who thinks that Adam isn't up to the task needs to understand that this is a man who actually has, I can't get it on the screen, there we go, who actually has his own doll. So he's already a legend in his own time. And I think that the fact that he has his own doll speaks very, very well of the kind of work that he's going to do in the future for the association. What I want to talk about is some hot topics. I went to the C.A.R meeting, as did Jeff, and of course we went to it virtually. And so I want to talk about a couple of topics. First of all, topic actually that was brought up by Adam and a couple of others at another association, and it has to do with forms that are not created by C.A.R. Oftentimes because it's a new home tract, or now we have companies that are coming into the brokerage business that haven't been in it before. They're asking you, telling you that you must use their forms. And so I want to talk about that a little bit. I also want to talk about waiving contingencies, some cancellation issues, and then we'll see how much time I have left. So in terms of using forms that you're not familiar with, remember under Article 13 and a number of provisions of the Department of Real Estate regulations, you are not allowed to practice law without a license unless you actually have a license to practice law. Even if you don't practice law, at least you've got the license to do so. So Article 13 makes it pretty clear that you don't practice law. That means that you don't interpret contracts. Now, you have a duty to go over contracts with people, tell them what's in them, but you don't interpret the language. You don't say, well, this means this, that the good faith provisions mean this legally. You don't do that. You're familiar with the forms. People like Barbara teach you what the forms say. You've got great training, plenty of access to information, but you don't prepare forms for the new home companies and certainly for others. I recently was sent some of the forms for one of these new companies, and I was frankly pretty surprised at the content. There were a lot of rights being waived. There was some serious question in my mind about whether some portions of the contract could even be construed as illusory because they were so one-sided. C.A.R understands that they're representing buyer's agents as well as seller's agents, and so they make most of the forms basically neutral, whereas these forms are clearly not neutral. So you need to be careful about using forms that you're not familiar with, unless it's your company form. Some of the companies have their own addendums, their own advisories and things like that. But if it's a form that was not created by C.A.R. or by your company's attorneys and or your company's brokers or risk managers, you need to be very cautious because of Article 1. Because if you miss something, there's a real good chance that you could be waiving substantial rights on behalf of your client. Also, you could be waiving disclosure rights. For example, in one of the addendums that I saw, it said that to the fullest extent of the law, you were waiving all disclosures in the C.A.R RPA. Well, one of those disclosure forms is not a mandatory form. The TDS is mandatory, but the SPQ is a contract form. It is not mandatory. It is not a state law that you use a TDS. It's not a state law, frankly, that you use an AVID form. It is only a recommendation. What is mandatory is that you do the visual inspection. So be careful about that, because the TDS does not have all the information, or even close to all the information that's contained in the SPQ. And of course, if you waive the right to that SPQ and you don't get one, and something comes up later and you didn't clearly make it understood to your client that they were waiving certain rights, you could be in a world of trouble. Not to mention, more importantly, that you could be getting your client in some trouble because they're not getting the information that they might need. And since 70 to 80% of lawsuits come up in the disclosure arena, when I saw that, I got a bit concerned. So be careful about using forms that you are not familiar with. And again, we're going to do a little bit more talk about this, but I don't have a great deal of time today to do that. So for right now, if you get a form, it's not a C.A.R form, it's a company-driven form, or a contractor-driven form, or a new home builder form, be very cautious and suggest that the buyer consider using their own attorney and getting some legal advice but whatever you do, make sure it's clearly understood you're not giving any legal advice. Lately, we've been seeing a lot, because of the market, obviously, a lot of waivers of contingencies at the get-go. There are 9 pre-printed contingencies in the standard current RPA. And of course, some of them are not applicable to every transaction, but some of them are applicable to most transactions. The loan contingency, the appraisal contingency, the home inspection contingency are all pretty consistent in every transaction. One of the that I've seen, not necessarily around here, but I've been getting a lot of calls in other in other areas dealing with the waiver of the appraisal contingency. And you need to be very, very careful. We did a legal panel last week, and the issue came up, and we were very concerned because, first of all, understand what a contingency is. It's nothing more than a condition to protect the buyer from their duty to perform. So if I have a contingency to get an appraisal and the property doesn't appraise, I have the ability to cancel without being in default. And if I cancel without being in default, I get my deposit back. It's called a condition precedent, and you guys call it a contingency. That's fine. So you need to be careful about waiving contingencies without clearly documenting your file that you and or someone else, an attorney or someone else, carefully make it clear to the buyer what they're waiving. For example, if you waive the appraisal contingency, doesn't mean you can't go get an appraisal. It simply means that if you cancel for failure to have the property appraised at the purchase price, which miraculously it mostly does, then you're not going to get your deposit back for that reason. And I'm going to talk about cancellation issues in just a minute, because there's been some significant shifting in that area. So again, it's not illegal to waive contingencies. There's simply negotiated contract provisions. C.A.R. has put a bunch of them in your contract, so it's expected that you're going to be using most of them. But if you waive them, you better make sure that your buyer understands what they're waiving and what's at risk, and also be careful, of course, that when you do make the explanation, that you don't step over the line and practice law without a license. So again, you can do it. The one contingency that I would be very, very cautious about, of course, is the inspection contingency, because again, if you've already waived the SPQ and now you're waiving certain inspection rights, you're putting your client and frankly the entire transaction into some jeopardy. So be careful about that. Be careful about again, waiving contingencies without fully understanding what's going on, and making sure, more importantly, that your client understands and that you've documented your file very carefully, and that in that documentation there is a response from the client indicating that they fully understand and have assumed whatever liability or risk might exist. At the recent C.A.R. meetings, we had a pretty interesting conversation about cancellation. For whatever reason, and it's historic, it's not new, probably one of the most disputed areas, and maybe you guys have had this experience, but certainly the calls that we get, the calls that Jeff used to get before he went to work for CRMLS, the calls that most of us that do risk management get, is about the deposit. I just got a call from one of my clients the other day. She's gotten served with a small claims action because the seller won't agree to return the deposit. And of course, that's because there's such an incredible misunderstanding by so many out in the field about who gets the deposit. In her case, she doesn't even have the deposit. It's with escrow. And of course, she's not a party to the transaction, but it's a misconception oftentimes by the buyer that they are, that it's the realtor that's controlling the deposit. So a couple of things. First of all, understand cancellation. There are cancellation rights up for both buyer and seller, and it's just going to kind of touch on we'll do a better job when Barbara and myself and a couple of other brokers restructure the RPA training for the fall when the new RPA comes out. I'll talk about that in a second. But remember, there are essentially 3 seller cancellation rights in the contract. Number 1, the failure of the buyer to remove contingencies within the set period of time. And of course, in that transaction, the seller must first give a buyer a notice to perform and then can cancel. The second, of course, is where the buyer doesn't close on time. And in that situation, the seller can give a 3-day demand to close escrow and then cancel. And then the third issue is if it's been elected by the seller to include the contingency for replacement property and does not satisfy that contingency, then the seller has the right to cancel. The buyer has 5 essential cancellation rights that are set forth in the contract. Number 1, of course, if the seller fails to provide the documents and materials that they're required to provide within that first 7-day period, the buyer can send in a notice to the seller to perform and then cancel. They can cancel based on the existence in good faith of one or more of the contingencies, and they cannot remove them. And I want to talk about that good faith issue in just a second. So assuming that the buyer is acting in good faith, and for whatever reason the property doesn't appraise or doesn't inspect properly and you can't agree on repairs and all those things, then of course the buyer can cancel and should be able to get their deposit back. If the seller doesn't want to close on time or can't close on time, then the buyer can provide a 3-day demand and conceivably cancel. If the transfer disclosure statement comes in, regardless of whatever time it comes in, there is a statutory 3 to 5 day right to cancel. And if the TDS is amended for any reason during escrow, it revives to that extent a 3 to 5 day cancellation right. So those are the cancellation rights that the buyer has. That, of course, then leads to the question of who gets the deposit back. And again, a couple of tips on that, because it's not clear all the time. The overriding question for the lawyers involved is there an issue of whether or not the buyer is acting in good faith? At C.A.R, we discussed a case. I think Jeff was there, and the case had to do with, I'm going to paraphrase, where a buyer enters into the transaction, a contract is formed, and a few days later, they find a house they like better. And they then say, well, we're changing our mind, we're going to cancel. The broker says, well, you've got your contingencies, so there should be no problem in safely getting back your deposit, sends an email over to the seller's agent indicating buyers changed their mind and they're going to cancel. And the seller refused to return what was a fairly substantial deposit. I think it was $50,000, $70,000 deposit, less than 3% of the purchase price. And the parties couldn't agree at mediation, so they went to arbitration. The arbitrator ruled in favor of the seller and said changing your mind was not acting in good faith, and awarded the entire deposit and the attorney's fees. It was $120,000 award to the seller and against the buyer. So again, it's not that clear all the time. So a couple of tips. Number 1, don't give an opinion that the deposit can be safely returned. That's not necessarily a realtor question as much as it is a legal question. Don't offer an opinion on what is good faith. Those are questions of fact that people like Jeff and I and Branden will investigate and will come to some type of a conclusion on. Sometimes it goes all the way, as it did in that particular case, to an arbitrator. Third, don't give an opinion on who's going to get the deposit back. That is an argument for the lawyers down the line, or the small claims judge if it's less than $10,000. Be very careful about what you say in text or emails about the deposit, and be careful when you're preparing cancellation documents. Obviously, I can't speak for Jeff or Branden, but In my perfect world, you would never touch a deposit or excuse me, a cancellation instruction, but you do. A couple of other things. I don't know how much more time I have, but on this hate speech issue, Branden touched on discrimination, which is the much broader topic. California has 20 some odd protected categories. The federal government has, I believe, 7 or 8, and NAR, National Association of Realtors, in Article 10 has 9. Okay, and discrimination again can be many, many things. Branden touched on a few. We've seen a bunch. It is an incredibly hot topic for liability. It is an incredibly hot topic at both the DRE and, of course, Department of Fair Housing. And when I talked to the Department of Fair Housing, they indicated even if they don't have jurisdiction because you're discriminating outside of a real estate activity, they will refer it over to DFEH. So if you go up on a hearing and you're found guilty of an Article 10 violation, it's supposed to go under the public trust doctrine to the Department of Real Estate or whatever state you're in, their governing body. In California, the DRE only has jurisdiction over real estate transactions, but according to the chief investigator at the DRE, they will turn it over to Fair Housing and let them decide if there's a fair housing violation. There is a new hate speech restriction, and it came out primarily, if you remember, Branden was talking about what was going on in Long Island, which was an incredible embarrassment, or worse, to organized real estate. When 49% of African Americans are not being treated the same as Caucasians simply because of the color of their skin. Basically, they were born with a certain pigmentation, and now they're being discriminated against and cannot buy the house that they dream about, or even be given equal services. There's something seriously wrong. And I'm politically conservative. It's not a conservative issue. It's not a liberal issue. It's simply a human issue. And that's true whether it's Hispanic or Asian or African American. So what NAR did is they said, look, we're going to create, because of what was going on during the summer and the incredible language that was being used in social media, they said, you know what? We're going to do something we've never done before. We're going to create a standard of practice that turns out to be 10.5, and we're going to say if a realtor engages in hate speech, which is a defined term, it's in the dictionary, look it up, or an epithet or a racial slur, and it is aimed at a particular protected category, that is going to be considered a violation of Article 10. And it will be true whether it's in the real estate transaction or whether it is in your other non-real estate activities. So a couple of things. First of all, it is not a First Amendment issue. It's not a free speech issue because NAR is not a governmental entity. It is a trade association, and they can restrict speech. It is not a state issue, again, because they can restrict speech. There's certain limitations to that, obviously, and Branden can talk about some of those restrictions. But the fact of the matter is, it's not a First Amendment issue. It isn't an issue regarding, it's not unlimited. I did a program last week for the state bar, and I was on, one of the speakers was the fellow, his name is Matt DeSantis, and he wrote, or was chaired this committee. And he made it very clear, look, first thing you got to have is hate speech. It's speech that is offensive to a typical ordinary person, right? I'm not sure who that is, but it's basically speech that any one of us would consider hateful. Comments recently I read about, Kobe Bryant and some of the terrible things that were said about him after his death, and some videos I've seen of some really unbelievable things. So it's got to be something that an objective person would consider hate speech, and it has to be aimed at one of the 9 categories. So we've seen a few already. We've had a few. Most of them have not been, as Branden mentioned, and as Adam mentioned, they've been mostly arising in areas where they weren't that clear on the face. It started out in the one that we're handling at another association. It started out as an argument between 2 realtors, right? Terry and I get into an argument over the way a transaction ought to be handled, and I call him a name, and then he calls me a name. And at some juncture, the name he calls me or the name I call him is aimed at his race or his ethnicity or something like that. I call him, in this particular, I can't talk about it because the case is pending, but I ramp it up to the point where now I've crossed the line. The other issue, and Branden and I are going to be doing a housing symposium in June, and we've invited a woman who specializes in implied bias. Lawyers have to do it. The program I did last week satisfied a lawyer's 1-hour requirement for bias training, which we have to do and have had to do for many years. So I think it's a very good thing. I would look, if I were you, and this is an issue that just from a moral standpoint, it's time for you to maybe take it up a notch. NAR, go to their website and go to Fair Housing and look for the video. It's 52 minutes long on implied bias. I did that. It was really very, very eye-opening because I grew up in a certain generation where words had different meanings, or they would be a joke, but they probably would have been and probably were 40, 50 years ago very hateful to the people that those jokes were aimed at. And so take a look at that video. It'll open your eyes, frankly, and I'm sure Branden has a lot of stuff on the state site or can point to some things that can be done. But Molly Stafford is a professor at McGeorge School of Law, and she's going to join us, and I'll get more information out because it's going to be open to not just the boards that are sponsoring it, but to some other boards as well. So the hate speech issue, bottom line, be careful what you say, especially on social media. And be careful what you repost. And be careful what you agree to. There's a case pending right now in Michigan, RE/MAX agent. Someone made a comment on the association or the site somewhere, I'm not sure where, about Black Lives Matter. Now you can agree, disagree, not like them, think they're real, think they're not. But what he did is he made a comment, and this is the last topic I want to talk about in this subject, and he said all lives matter. And he ended up getting fired, and now there's a wrongful termination case. I don't think that's hate speech, personally, because it's a point of view. And again, religious points of view and political points of view at the basic core are not going to be considered hate speech. Speech that's addressed to certain people. Politicians are not in a protected class, thank God. And so we're right now, according to NAR, they're working on creating sort of the guardrails of what is and what is not hate speech. And then, of course, the implied bias issue to me is within all of what we talk about the most important, because it's where you don't even realize you've crossed that line. The love letter is a perfect example. I had a case where the seller had 16 written offers in a 2-day period, many above the purchase price. She ended up selling the property to a buyer who wrote a love letter that said how well she fit into this lily white, well, she didn't use the word, all she said was, I can't wait to buy the house. I fit in so well in the neighborhood. Now, again, there was no intent, but there was a problem, right? You attach photographs, and so we'll probably get some questions and maybe address this issue a little bit greater. Again, topics I'm prepared to talk about today. I just redid my risk management class, and I've got, what do they call it, Jeff, when you steal from one person, it's plagiarism, but if I steal from a number of people, it's research. So I stole from a whole bunch of people, because Branden, myself, Jeff, we do a lot of these programs. I've been listening to lawyers, the guys in my office that do litigation, put together about 3 pages of tips of what to do and not to do. And I'm going to put that in the form of a newsletter and get that out fairly soon, but I'm also going to make it part of our risk management class. Last topic, and then we'll open it up to questions. I mean, I can talk for hours. I love the sound of my voice. I'm a lawyer, but the reality is that 2 more things. One, be careful about do not call. There was a class action that was pending in Orange County. There was a Ninth Circuit lawsuit. It just got settled, but then another lawsuit on do not call where you're using robocalls to make calls. I got a call at 6 o'clock this morning from some orthopedic institute. I was not a happy camper, right? And so these calls come in all the time. And so be careful about that. Be careful about using robocalls. I know Jeff and Ed Zorn are not happy campers when you use the MLS information to mine data and then make robocalls. Remember, you're not being invited to call those people. You don't necessarily have consent to call those people, so be careful of do not call. And then lastly, be very careful about, I don't know how else to say it. You have a great property management committee at your, I think Debbie is the chair this year, if I'm not mistaken. It's a really fine committee. I've met with them on a couple of occasions. Now is absolutely not the time to start thinking about opening up a property management business. Not only do you have the fair housing issues, which are complex, and I believe, Branden, there's like 50 pages of fair housing regs that were adopted on January 1st, but you've also got all the other fair housing issues, and more importantly, not more importantly, but much more complexity, you've got AB 3088, which is extended by SB 91, which will probably be extended again, very possibly. Plus, they've added now, in order to get satisfaction in the courts, you're going to have to establish that you applied for the rent money that's going to be coming available, and that's already available. Something like 1.5 billion initially, but now there's going to probably be a lot more because the president signed the stimulus package, and I believe some of that money is going to be earmarked for rent subsidies and rent relief. So there's so much right now. Great time to be a lawyer, not so great a time to be a realtor or somebody else. And then lastly, I just want to piggyback on something that Jeff said. Free is not necessarily free. The underlying reason for the rule from the Department of Justice, as I understand it, is people are advertising their services to buyers as free, but they're getting money from the listing agent, so they're lying. You can never lie in a real estate communication. It is a violation of Article 12. And if you advertise your services as free, but you are getting money from any other source for that service, whatever that service is, it's not free, and you have to disclose in writing to whoever you're telling that your service is free. You have to disclose in writing that what the source of that money is. So free better be completely, totally free, and most of the time it's not. So I've got a whole bunch of stuff, but I know there's a million questions out there, Adam, and now it's your turn to do a great job. And if you don't, I'm going to put put pins in this doll. So go ahead.
All right, John, thanks. And I guess in full honesty there, that's a doll of John Butler. He's just blessed to have the same haircut I do, I guess. So I don't quite yet have my own doll, but maybe one day, or maybe I'll keep it out of your hands.
Sure looks like you. Same haircut.
Yep. So what I'm going to do, I'm going to try to get through some of these questions here in the chat, and then we'll open it up to everybody else here as well. But John, real quick, just since you were talking about 10.5, I think some of the concern that we've heard is that, number one, it's kind of up to the grievance committee for interpretation of whether or not it's how that, if it's perceived as hate speech or not. So can you comment on that? And then number two, I think what everyone's big concern was when it first came out is where does the line get drawn, if ever? If I'm at a table telling a joke and the punchline happens to be against a protected class, does that then put me in violation of new 10.5? Can you comment on that?
Yeah, am I okay? Am I unmuted?
Yes,
okay,
you're good.
So first of all, that's going to be an issue. The first question is really goes to the issue of the political speech, the the religious speech and all that. And then talking to Matt, they're going to be doing case interpretations to try and not defeat the purpose of this. The purpose of this wasn't to basically prevent legitimate political discussion, to prevent legitimate religious beliefs. In fact, for some of you who attended, we did some training on January 7th. We're putting together hypotheticals, and the next time I do training or have a brown bag, I'm going to have hypotheticals available, and I'm going to throw them out. Things like I'm a pastor who's also a realtor, and I have a podcast, and in the podcast we talk about gay marriage. At what point, if any, am I not allowed to do that? Now, there are issues, we could all debate them, about the so-called cancel culture, and I think that's really where the rubber's meeting the road in the conversations I've had, is people's concern that they're perceptively, whether it's true or not, are obviously open to argument, but the perception is that there's two standards of speech in America right now. And so what we're doing with all the grievance committees, not just at Southwest, and I have very little concern about Southwest because frankly, we just haven't had the issue. It's been either we've turned a blind eye to it, or I haven't seen it. But we're going to be very careful. Initially, as you know, my law firm, through Linda Conaway, administers your professional standards program. And if she gets a complaint in, she has a standing instruction to let me know. Whether I'm here in Tennessee or wherever I am, we're going to look at that first, and then we'll try and make some sense. I may call Branden. He's on the speed dial. And I may say, Branden, what do you think about this? Branden's obviously got both feet firmly on the ground. I value his opinion tremendously, and if I need to, I'll go to other sources. I'll go to NAR. They're on my speed dial too. We'll figure that out. Where I'm concerned is certain boards, no matter what you say, it's not going to be hate speech, and that bothers me. And then some other boards, because of the makeup of their board, the overriding political affiliation, just the area itself could lend itself to some concerns, the so-called vigilante concern. Haven't seen it yet, Adam. Haven't seen it at all. But people need to be careful. People need to be careful. NAR made it very clear that they were raising the standard. So if you think this is supposed to fit into the standards that we're used to, simply not true. They made it abundantly clear at the time they passed this and since that we have raised the bar. We've said, and Branden pointed out, there's a book, by the way, tremendous book. It's called Color of Law. I urge you all to read it. It'll open your eyes. It's time to say, look, this isn't about my political affiliation. This isn't about my religious affiliation. But if a gay person has the money for a house, if an African-American person has the money for a house, then the color of their skin, the genesis of where they were born, their gender should not matter. What matters is I have the money to buy the house, and I otherwise qualify, and that's the issue. And so that's that. So I'll shut up, but I'm sure Branden might have a comment or two, but I know we have a lot of other questions. It's a very complicated topic, no question about it.
All right, thanks, John.
Thanks, Janine. It's called The Color of Law. I think Branden's guy whose name was Rosenstein.
Richard Rothstein.
Rothstein.
Yeah,
sorry
it's
about
a
that.
wonderful book.
Richard Rothstein. Yeah, it is really a very, very, especially if you love history, it's a very good book.
All right, John, thanks. So here's what I'd like to do. We've got just over an hour to try to get to as many questions as we can. If you have questions, if you could stop putting them in the chat, I'm going to try to run through those as quickly as possible, and then we'll get to some hand raises so you guys can ask the questions directly. Want to remind everyone, this is not legal advice. We're trying to keep this general, but get as much information as we can out to everybody. And then if questions come up, that are a little on the uncomfortable side, just remember we're all adults. Let's try to keep as much respect for everybody as possible. I'm also going to ask, which this could be a big ask of 3 attorneys, but if we can try to keep the answers or responses concise, that just gives us more time to get to some more questions here. So let's jump right into this. And I think the first question here is probably going to be for Branden. And let me scroll back here. Essentially what the question was asking is there ever a time where a buyer, or excuse me, a homeowner can discriminate, and that was a word that was typed in, discriminate, when they're renting a property, say like a casita on their property or an adjoining wall or maybe another unit that's on their land? Do they as homeowners ever have a right to decide who they can or can't rent to?
Sure, no, that's a question that's really grounded in some of the history of fair housing laws. Let me say, general answer is going to be no, and let me work our way there. So folks may be familiar with the Federal Fair Housing Act. When that law was passed, there were concessions made to, honestly, to get southern states and folks to pass it. And some of that was to exempt certain homeowners. And the small-time homeowner who didn't make a discriminatory statement, owned less than 4 properties, they were exempt. And that's still the case in many states, not here in California. So let me just make it clear, not here in California. So the only person who's ever going to be exempt from fair housing laws in the state of California is generally the very limited circumstance of someone who is the homeowner is living in the home and they are renting out, a room when they'll be sharing facilities. That's the only time, and it cannot be a discriminatory statement. It certainly can't be, a broker involved in that as well. So this is usually where, or a realtor, this is usually like the private homeowner, going back to our agrarian days of, being able to kind of have a border in your home and have some level to distinguish that. But so it's very limited. You know what I'm saying? It's not, so if you have a casino, if you have a separate address, if you got a separate property, you're not renting out a room in your home. You're renting out a separate property. So you're on the hook of being a landlord, similarly to renting out more than one room. Back in the foreclosure days, I remember, renting out 5, 6 rooms. I mean, you're a landlord. So it's very limited to that narrow circumstance. So it's really, that almost like that right of intimate association, right? That's protected where it's just me, it's one person, we're living together. So it's very limited to that extent.
All right, thank you. Another discrimination related question here. If you are a 55 plus and have a child that you care for because they have a disability or special needs, is it discrimination when the HOA will not allow you to purchase or move into the area? Is that a case for discrimination?
Let me say a couple of things. One, their rules differ whether it's a 55 and up mobile home park. Secondly, someone truly has to be a 55 and up property. Many folks may claim that they are 55 and up, but maybe they're not doing age verification or doing any of that. It's true that in a straight up lawful 55 and up place, there can be, they are allowed to discriminate on the limited basis of people under the age of 18, children, right? That can be done. However, and this is where, honestly, off the top, I always have to go dig into the code on this, because I always confuse the mobile home section with the general section. But generally, there is a need for reasonable accommodation under fair housing laws. And so if this is a situation where maybe someone needs to stay for an additional time, or they may have a need to be there related to a disability, a housing provider is going to have to consider that reasonable accommodation, because that's the whole point of an accommodation, is it's an exception to the rule because it's necessary. And is it truly necessary? It's a case-by-case basis, I would say, too. It's not like we can just say the rule is, in any case, someone can come in. But there may be circumstances. So I would say it's case-by-case, but remember the right of reasonable accommodation to policies and procedures.
All right, thanks.
Can I also want to correct an assumption in the question. I agree with Branden that I would be looking at a reasonable accommodation, particularly in the child, because you've got both ADA and familial status issues there. The other thing, it's not a purchase restriction, it is a residency restriction. So I can buy 10 houses. If I'm 30 years old, I could buy 10 houses in a it's a civil code section 51.3 housing. I could do that, but I can't rent them out then to unqualified people. But there's always an exception to the rule, and I'll tell you what, in light of the exposure, I'd be very careful if I were the attorney for that homeowners association. I know, Jeff, you used to do a ton of homeowner association law, and I don't know if you think what you would be advising an HOA on that topic, but I'd advise them to be very, very cautious about the reasonable accommodation issue.
Thanks.
Yeah, the HOAs, I mean, they're gonna have a lot on their plate with this. It's just gonna come up down to, it's gonna be fact sensitive, you know, and then they're gonna have to send it over to their counsel. Most of the, you know, covenants, codes, and restrictions, the CCRs are fairly modern, and so we don't find them getting too many questions about this based upon their written rules. Some of the older ones, though, you know, we've had to go back and well, in my former capacity, we would have to go back and tweak those. But yeah, it's not a good time to be someone who is in charge of a large scale development and governing it, because there's a lot of loose threads hanging out there.
Yeah, and I would just, lastly to say, a lot of times this issue comes up more when, you know, the accommodation was granted and then the non-disabled homeowner, you know, passes away, and then you have the disabled person, you know, underage living there by themselves. And, you know, the issue of, you know, that's, I think sometimes where this comes up a lot more too, is at the after.
I agree.
Yeah. All right. Thank you. We've got a lot of agents, you know, that might speak more than just one language. And is there any risk of putting that on your business card that you speak another foreign language or multiple foreign languages? Is there any risk that could be perceived discrimination?
Well, I'll say this. I can't give an advisory opinion, but I'll say this, that, you know, generally the rules with language are, you know, it is discrimination when we only advertise in a language other than English, right? So if I'm only, you know, advertising in Spanish, well, that's a concern because it's indicating a preference, right? You know, the people who speak English can't read this. So the traditional rule is everything needs to be in English. If someone also wants to advertise in the other language, that, you know, again, case by case, it could be used as evidence, but generally, no, that's not a problem because you're advertising in English. You're saying everything in English. But like I said, it's the opposite is generally where there's a problem when you're saying, you know, only Ukrainian. And then it does indicate a preference for who you do want to work with. And that's the whole thing with speech. Is it indicating a limitation or a preference? And if the answer is no, I said the same information to everyone. I just said it in other languages too, because, you know, many folks here speak this language. No, but you got to do both.
All right, thank you. This is a comment here for probably Jeff. An issue in our region that we're starting to see more and more of is that of grow houses. And the question is, could there get a field put into the MLS stating if the house was formerly a grow house? There's the comment here is, I do not see agents disclosing an MLS on obvious reported, rated, and rehab grow houses as listed for sale or sold.
Right. Yeah. I mean, there's a species of concern that people ask us about whether or not here at the MLS we would require any kind of disclosure, such as death on the property or you know, toxic waste or things. Keep in mind, the MLS is not the governing authority on what you need to disclose to the sellers. The law on that is basically, you know, vis-a-vis the DRE and the civil code. So here at the MLS, we don't go down that road. We don't have boxes to check for death on the property. We don't have boxes, you know, to check for, you know, toxic waste and things like that. If you want to, you can put things like that in the private remarks. That's up to you as a listing broker. You want to get that distributed that way, but keep in mind those private remarks are going to other agents. Frankly, you could put that in the public remarks. I don't know that that's what you want to do. I mean, if there's really have a good reason for it, again, that's entirely up to you. So we give you a lot of flexibility as to what you can disclose. We don't want to get in the way of how you market the property, but we don't put requirements on disclosures. Those are best handled in the context of your transaction in writing in that respect. And you got to be careful too. I mean, we talked about this at John's Legal Forum last week, well, Ed did actually. you know, you have accountability for what you put in the MLS, that it has to be accurate. And you also have liability, you know, to some respect as to that accuracy. So again, less is, you have to be somewhat careful in what you're putting in the MLS. I had a situation where a client came, a realtor came to us and said, hey, I need you to go back to this closed listing and take out some of these comments that I put in the private remarks about a former flood or some sort of, there was an environmental problem on the property. And I'm going to say absolutely not. First of all, I can't remove historical information from the MLS under the California Civil Code and under our rules. But what was pretty obvious to me is that this person was getting sued, right? And they had a situation where it was a disclosure issue. And what I came to find out is the seller was saying that never happened. And yet, you know, there was a big to-do about it. So I don't think that the MLS is really, we're not necessarily interested in getting involved in it. And I think that you should be careful as well to keep your disclosures in a controlled environment within the context of a transaction. I just, you know, check with your broker, but it's up to you how you want to talk about your property, your listing. We're not going to ask you or require you, and we're probably not going to entertain ideas of starting, you know, in the disclosure fields in the MLS.
All right, thanks, Jeff. John, this one might be more directed toward you. And we've had a little bit of talk here at the association level about other companies. This one particularly mentioned Zillow and how they're, you know, stepping more and more into the business, and how their advertising could be perceived as deceptive or untrue and lying and whatnot. Is there any, what can be done about that? Is there any recourse, or is there any standards? Barbara Horan did respond over there about, you know, if they're not realtors and whatnot, but can you touch on that a little bit?
Sure, and then Jeff can jump in too. Actually, Branden, there's issues there. First of all, general statement, it isn't about Zillow, it isn't about Showing Time, it isn't about any of these companies, because we don't worry about you know, specific business models. That's not something we're going to worry about. Those are antitrust, boycott related issues. So this comment is general in nature. Number one, if they are truly have joined either an association of realtors anywhere or an MLS, particularly Jeff's, then their members no different than anybody else. And so I know that I saw a video, I think it was about a week or two ago, that Connie sent me, and a couple of other CEOs sent me, that was claiming that a particular company was actively interfering in the exclusive right to list. Well, that's an Article 16 violation, and I don't care what company you are, that's still a violation. If they're violating one of the MLS rules, I don't care who they are, it's one of Jeff's rules. And everyone is treated the same, not worse. We're not going to look harder because they're, you know, a company that maybe we don't like the business model, because get used to that. Business models are going to change dramatically over the next decade, I'm sure. But the fact is that they have the same obligations, they have the same rights as everybody else, but they also have the same obligations, and those include obligations to comply with all the rules. So if you see any company, Zillow, Redfin, Keller Williams, anyone violating a rule, report it. You have one of the best professional standards departments around. I know that because I represent most of them. And you guys do a phenomenal job. We'll investigate it. They'll file a complaint. Doesn't matter who they are. They can't violate your rules. Period. End of story.
Jeff, did you want to add anything to that?
Yeah, I kind of do. John just introduced the idea of antitrust issues when you're talking about particular entities. I want to feature that a little bit for you guys, because I'll give you some background on the NAR law, or the PLS lawsuit against our company and against NAR. They used as evidence in some of their declarations comments that were made at public meetings, okay, at the NAR MLS committee meeting in November of of 2019, some representatives from some of the MLS defendants in our case were up there, making comments. And those comments eventually made their way into a declaration in an antitrust case. And again, one of the key elements in an antitrust case is competitors coming together in an agreement to do business in a way that prevents one of their other competitors from doing business. It's discouraging and stifling competition. And nowadays, here, for example, just in this meeting, if you start singling someone out and you're talking about them in a way and people are agreeing in the chat and saying, yes, we need to stop this person or that person, be very careful, right? And the other thing is you don't know who's actually on all these meetings. One of the executives from another AOR that, John did a legal meeting last week was talking about an app called Clubhouse. And there was a discussion going on, and she gave some some evidence as to something that was being talked about, and she came to find out that one of the people listening was from the Consumer Protection Bureau, right? And this person sent a tweet and said, "I'm glad you talked about that." Very surprising, and kind of makes your hair on your back of your neck stand up. That you have to be very careful, and so if you have strong opinions about something, that's one thing, but you have to be careful that you don't venture into creating evidence that we are agreeing and conspiring that we don't like this particular entity. Guys, this is not the time to do that, if ever, right? Because again, these cases that have come out, that's all evidence. So as John pointed out, if someone joins our MLS as a broker, right, which has recently happened with a very, very large company, they are to be treated equally under the rules, and they have the same rights and responsibilities as any other broker. So just a note of caution for you.
I appreciate that.
And don't worry about it. Real quickly, I just attended a meeting. One of my boards had their strategic planning meeting, and we had a speaker, and the statistics are overwhelming that people are using realtors now more than ever before, right? So the fact that you're attending this meeting, the fact that you do the things you need to do, that's what is going to set you apart, right? People, the transaction is so complex in California, especially. And frankly, I bought property in another state recently, and it's almost as complicated there. You wouldn't think about buying or selling a property without using a realtor, and most people are that way. They're going to use a realtor. So really, it's all about the service you provide, the relationships you form, the competency you bring to the table. That's not going to change over the next 10 years. Yeah, the fluff and the circumstances surrounding all that might change a little bit, and you'll either keep up with it or you'll go to junior college and find another profession, right? I mean, the fact of the matter is that you got to keep up with the times, and some of these companies have just invented different mouse traps, not necessarily better, but different. At the end of the day, though, it's going to boil down to what I know that Branden and I and Jeff and I, when LegalZoom came out, oh my God, all these lawyers were, my God, there's LegalZoom now. The best thing that's ever happened to us, because they, the fact is they take cases that most of us don't want to take because it's just not lucrative enough. And then when the really complex stuff comes, we get the work anyway. Don't worry about it. I've been doing this now for 30 years with you guys. You had 600 members when I became your lawyer. You got a lot more than that now. And you know what? I've been hearing it for the last 30 years. Oh my God, the banks are going to get into the business. Oh my God, we have virtual office websites. Oh my God, now we've got to deal with IDX and blah, blah. It still boils down to who gives the best service, who knows the most, and then your marketing campaign certainly is important. So thanks, Adam. I had to get on my soapbox for just a second.
No, I appreciate that. And I was actually just going to highlight one other thing that you mentioned is, we have a process. Our association has a process, to handle complaints. So, and we're a self-policing industry. So there's a lot of people out there that will complain about something, but never report it. And we can't really fix anything unless it's been reported. So just want to throw that out there, make sure everyone is aware that there is a process. And if you have questions and you have concerns, the worst thing you can do is sit back and do nothing and expect something to change, because it'll never happen. So
Exactly.
Okay, another kind of two-part question here for you, John. Probably a shorter answer here, but can a seller for a commercial real estate require a non-C.A.R form be used? And then maybe just a follow-up on that is, are non-C.A.R forms covered under E&O?
Okay, the answer is yes, and I don't know about your own E&O. I'm guessing you'll have to look at your policy, but C.A.R does back its forms, its current forms, so you got to be using a current form. But yeah, they do back their forms. But the fact is that the seller can demand, so long as the seller doesn't cross any lines that Branden would be concerned about, or cross any lines that Jeff would be concerned about, the form of the contract is not necessarily a legal issue. Obviously, some of the forms that C.A.R produces are mandatory, like the TDS, for example, and some of the other mandatory forms. But no, the seller in any, whether it's residential or commercial, can say you will use this form, and so they can do that. That's where you need to be careful, because if it's a form you're not familiar with or that you've never used before, it may cross the line between the unauthorized practice of law.
All right, thanks, John. Branden, let's go to you here. Question says, I've had buyers ask if the owners in this area are more Republican or Democratic. Do we have to answer that?
Well, I mean, I would say it this way. In terms of the Fair Employment and Housing Act and the Unruh Civil Rights Act, there's not a protected basis for political. However, there is one under the Ralph Civil Rights Act, which prevents threats of violence or actual violence on the basis of a political affiliation. So, I mean, long way. And then the other thing I would say too is, wondering about again, not an advisory opinion, but just educational points I would point out when someone says that to me is, yeah, on its face, not a protected basis. However, we did talk about the theory of disparate impact, discriminatory effects, and are certain political parties more likely to be one race or the other? Is that a code word to communicate something you're steering? I mean, it raises some concerns. I don't know why it's relevant, and I think from a risk-adverse perspective and educational perspective, those are things that the buyer can look up, if they are really concerned about what that is. Because again, raising the issue of, while not on its face discrimination, is behind that some motivation to get language about race out or otherwise. So I would just say, don't have an advisory opinion on it, but just I always wonder about things that are not necessarily totally relevant to the transaction and could be available by other public means without, from a realtor perspective, putting you in a situation where you're saying, well, it's actually more, this political affiliation, and okay, so therefore it's more likely blank race, or starts to go down a road that you may not want to go down, or could engage in some issues. So again, not on its face, but just in terms of fair housing and kind of the higher models being set forth, there's all, from my perspective, I would just want to make sure there's not, we saw the Newsday video, the coded language, the implicit bias. I just think is it really relevant? I don't know, just throwing out issues. Sorry, I'm not directly answering that, but I'm just saying it's not on its face in the FIHA, but there's things to consider.
All right, thanks. And there's a couple of questions that are coming in kind of specific. So I'm going to ask one other question here from the chat, and then I'm going to go ahead and open it up. We're going to use the raise hand feature. So if you don't know where that's at the very bottom of your screen, there's a button that says reactions. If you click on that, you can click on raise hand, and then we'll try to go through and get some of those. That way you guys can ask the questions directly and don't leave it up for me to maybe misinterpret. But I got one other question here for Jeff, and this has to do with MLS violations and citation. And the question is there some sort of scaling of fines based on the size of a brokerage? The example given here is that a $1,500 fine could really hurt a small independent brokerage, but a large brokerage can probably chalk that up to no big deal. Is there anything like that that's taken into consideration?
Well, not at our here in the compliance department, okay? And the reason is because we have to apply things evenly, otherwise we get accused of doing things in an arbitrary manner. I mean, you guys talk, right? So if we do something like that and that word gets around, then obviously, you know, everybody's going to come, you know, wanting that. And really, you know, how do you distinguish, right? Who is able to afford it and who isn't? I mean, we're really not going to go down that road. I mean, what are we going to have to ask for the corporate tax returns and things like that? That's just unworkable. But if you feel like that is a good reason for you to have your fine reduced, if there's some sort of financial hardship or something, you have the option, okay, to file for a citation review. And I can't tell you whether or not that will be an availing argument before either in a written review or before a hearing panel. But I will tell you that if it's at a hearing and I'm there, I'm going to leave that up to pro standards. I'm going to leave that up to your peers, your colleagues, to determine whether or not that's a legitimate reason to reduce your fine. I take no opinion on that. And as I just said, I don't think that's a workable approach for us at the MLS. If you want to talk about it and get your fine reduced, file a review and let your colleagues and your peers, the other practitioners, make that decision.
Yeah, and I think the first part of your comment there is true. I could easily see that opening up more questions about potential discrimination or favoritism or whatnot. So definitely appreciate that. Okay, Deborah Thomas, you should be able to unmute yourself now and go ahead and ask your question.
Hi, as John indicated, I'm the chair of the Property Management Committee right now, and one of the subjects that it keeps coming up is source of income. And one of the items that seems to be across the board people are feeling is that unemployment income does not have to be considered as part of income because it is temporary. And we'd like to know if that's true.
Well, you know, the definition of source of income is, you know, our lawful, you know, sources of income for which unemployment insurance is. And, you know, often when this question comes up, I always say, because this would come up with like in disability too. People would say, hey, are you going to get that disability check forever? Can you get a letter from the government? Of course you can, right? I mean, same thing with employment, you know, job can be done tomorrow. Could be closing down pandemic. So, you know, so the question is really, what is the source of income? If it is unemployment, that is a source of income. And do they meet the qualifications with that source of income, right? So with unemployment, you know, you're going to look at that as part of their income, part of the household income. So it would be included. You cannot say, I will never rent to someone who's bringing in unemployment income, right? Because they may meet the qualifications now. Who knows what other income they have? I mean, that maybe is savings or other things that may not be able to be verifiable through a employment group. But yes, source of unemployment is a lawful source of income, and you cannot discriminate so long as someone meets whatever those qualifications are of the non-discriminatory qualifications are. So oftentimes someone may not meet that on unemployment, right, if it's really low, but some folks may be at the higher end of unemployment or may have some other deal and be just fine.
All right, thanks, Branden. No other hands raised. I'm going to go back to a question. Actually, this one just came in, and I hear this actually out in the field quite a bit. Says, I'm having a really hard time getting tenants to cooperate with realtors when showing the home that is on the market for sale. They refuse to allow anyone in due to moratorium. What are ways that this can be handled, and what right does the owner have to sell their home? Please help.
I guess I can take an initial shot at that. Number one, look at your lease. If your lease has a provision that requires the tenant or tenants to allow showings based under current California law, then you provide the proper notice, and if they fail, that is technically a non-protected, currently under the new AB 3088, it is an unprotected breach of the lease. So long as you provide that tenant with the appropriate PEAD form, so long as you make arrangements for that tenant to be off-site when the people show up, or make that recommendation at least. And so long as you don't interfere with their quiet use and enjoyment, then you probably have the right technically to evict them, whether it's for a showing, a legitimate showing, although remember, showings are supposed to first be by virtual and then by physical, but for showings and or repairs. However, and this kind of goes back to something that Branden touched on, you better also look at the facts of your particular situation. Because if I'm a tenant who has a person in the property, or is a person in the property that is in that category where 70% of the deaths have occurred, then you may have a legitimate pushback. And good luck in finding a judge that will evict that tenant because they wouldn't let someone in. So again, what I'm seeing, Adam, in this world, particularly in an area that I know I'm not supposed to say this, but I'll say it anyway, tends to be more conservative, is that there's a presumption that the tenant is acting in bad faith. There's a presumption that their response is not legitimate. And I'm telling landlords, and I know Debbie, your group is telling landlords, you got to look at it on a case-by-case situation, right? You got to ask yourself, is there a person in the property that's older, has diabetes, has one of the situations that exposes them? Have they had their shot yet? And deal with it respectfully, right? Because if you're showing the property,
Oh, John, we lost you there.
Yeah. Well, and John, I'll just, while you're getting your sound together, I'll just mention, I think, John's point, which is what we talked about before with reasonable accommodation, right? You may say, hey, I need to show the property. Then you have a tenant who says, hey, guess what? I'm just recovering from chemotherapy. The doctor says it's unsafe. You may have to, there may need for an accommodation. Perhaps you're gonna have to work with them or find a time that can be very, very flexible to their needs. But it's going to be case by case, as John said. But yes, you do want to make sure, and it's always that, whether in a pandemic or not, a tenant may make a request and say, you know what, I'm getting my dialysis treatment in the house at that time. I can't do it. I can only do it from this time to that time because of my disability. It's unsafe. Now, does someone have an absolute right never to say you can never come in here under any condition? I mean, I think that's going to be strong, but maybe it's a period of time longer than one would like because of COVID, et cetera. So it is case by case, but I would just say that's the only kind of fair housing angle as to that.
I hit the wrong button.
Thanks for jumping in, Branden. John, I can hear you back now. Do you want to continue on?
No, I think that's basically it. I think the two magical things are be respectful. Be respectful. I don't care whether it's financial or whether it's showing. Be respectful, number one, and don't presume the worst in your people. And then if it is the worst, then you have remedies. And the word that's used that I see is the word have be interactive with people. Speak to them. Talk to them respectfully and interact and find out, is there a time that's better? As Branden said, maybe it's a physical thing. Maybe it's when I'm worried because my kids are home during that time of the day, and work with. There's a case, and Branden's right. Doesn't matter. There was an open house case a couple of years ago, nothing to do with pandemic, where the tenant was refusing to allow people to come and look at the property or to have an open house or anything like that, and it went all the way to the Court of Appeals, and the court said, look, so long as it's during normal business hours and it is something that is worked out, right? I call Branden to say I'd like to have an open house or a showing. Branden says, well, that's my daughter's birthday. We're having people over. No, right? You got to be respectful of those kinds of issues. But if it's a blanket, you're never coming over, I'm not cooperating, then you have remedies, document your file, and move forward. It's been an issue, by the way, Adam, since day one. The showing issue has been one of the most commonly asked questions, and we had to, frankly, power our way, fumble our way through to the point where we are now, where we think we've got some answers, which includes the right to evict for breach of the lease, but we still don't have courtrooms that will allow us to do that under most circumstances. I just got a notification on a simple quiet title action that I'm going to trial in 2022.
Oh, gee.
Your kids are going to be in college by the time I get tried. That case gets tried. So, you know, there's a practical aspect to all of this as well.
Yeah, no, I agree. Thanks, John. Guys, we've got time for questions here, and I don't see any hands up. This is your opportunity to ask away.
Armand just raised his hand.
Okay, let me make sure he can unmute. Thanks, John. Armand, you should be able to unmute and ask your question.
Hi, guys. Thank you for the opportunity. So anyone who can answer me properly regarding this question, either John, Jeff, or Branden. So I was, this question is particularly regard to the buyer agency, and is realtor allowed to have any sort of rebate to their own client? And if it is, how can it be announced into the contract or to the agency? Or can it be a separate contract, or can it be a different amount to any sort of their own client, or how it can be advertised through social media? This is a general question, which it just always go across my mind. And how can we address this? I really appreciate that.
Adam, I had a hard time hearing it. Can you repeat the question?
So essentially, I think what he's asking is there, it might have even been typed in earlier. Could you please tell your opinion on realtor rebate to your own client? If you're using it from your own compensation, can that be advertised on social media, or can it be different for individual clients? How can you announce this into the contract, or is it even allowed?
Well, and I know Branden's going to weigh in on this. You know, you can't say, well, you know, I'm giving a 10% rebate to all my white clients and a 5% rebate to all my African-American clients. But other than that, you can work for free. You can give a rebate 100%. Again, there are rules under RESPA and some other rules for how you give referral fees, rebates, and all that. But no, the issue though, so if I'm saying to buyers, you know, I will rebate, you're not sharing your commission because that's a DRE restriction, but you're basically giving a rebate of a certain amount. It's perfectly valid. And again, be careful of how you do it, that it's consistent, that it's not based on one of the criteria relating to fair housing, but you can do that. Sure, you can work for free. Be careful, however, if you're the listing agent and you're offering rebates to buyers that are currently working with other realtors, because if you're using that as an inducement to get someone to leave a buyer's agent and come to you, that could be a procuring cause issue, and you may end up writing a check for the buyer side commission if you're successfully able to lure that buyer away from that buyer's agent. That could be an issue in an arbitration of procuring cause. So be careful about that as well.
Thanks, John. Branden, did you have anything to add on that?
No, John's exactly right. You know, you're operating a business. You can't discriminate on any protected basis. It has to be the same rules apply to everyone. And even just remember there's such things as arbitrary discrimination, which we didn't quite get into, but you can't be arbitrary too. I mean, there's a whole test for that, but just make sure you're giving everyone the same deal, regardless of who they are, or there will be a fair housing issue.
Great, thanks, Branden.
And Branden, don't you think that that's the overriding issue, is treat everybody this, you know, obviously there could be some disparate income issues, but aside from that, treat everybody the same. Same level of service, same, everything should, if you're treating everybody exactly the same, I kind of like that blind orchestra. I'm worried about the word blind, if that would be offensive today, but other than that, if the fact is that if you put blinders on, even those love letters, if they're absolutely, I can't tell from the letter or something like that, treat everybody the same. I think you're gonna generally be okay for the most part.
Well, in the
It's where
Newsday
you treat
video,
people differently.
in the Newsday video makes that simple point, you know, just said, look, it's really not that hard at the end of the day. You know, you have the black prospective buyer, the same information you're giving the white prospective home buyer. And there were many realtors in that video who did comply with the law. They gave the exact same information to whoever came in. And at the end of the day, it just treat everyone the same. And you're not going to run into problems with fair housing if you, I think, live by that principle.
Yep, it's the old-fashioned golden rule. Next up, Vicky Hightower, you should be able to unmute and ask your question.
Yes. Well, my question was the one that started with the tenant that refused to allow the realtor in. I did want to say that we originally gave the tenant a notice of termination of tenancy May 7th, 2020, and we have extended the move out date or to place a home on the market due to COVID. And every time it's time for that expiration date to expire, it's something else. So at this time, since she will not allow the realtor in, and I serve her the notice of covenants to quit, if she doesn't, or if the couple doesn't comply, then we should be able to move forward with an eviction. But keynote is the tenant, this is a pre-existing tenant, and the owner created his own lease, and there is nothing in the lease about the right to sell a home.
Like I said, when you use unfamiliar forms, you know, again, Neil Kalin, Howard Fallman, and all the people in your forms department at C.A.R. are phenomenal lawyers. Phenomenal lawyers. Robert Bloom is the landlord-tenant guy over there, and they do a great job. So when these landlords wanted to save it, you know, again, I don't mean to be sarcastic. Well, yeah, I do. But there's a landlord who decided he wanted to save a few bucks. He used his own form, and it's not adequate. And now you have to deal with it because that's the written contract between the parties. And you might want to, so you know, you have to deal with whatever is in writing. That's why I'm a big advocate of the C.A.R. forms, because it's their job to make them adequate, and so too bad.
Okay.
Too bad.
All right. So I guess I should not pursue this, because if it was heard in court, a judge would view it as there is nothing in this contract for the claim that while you're evicting them.
I can't give you specific legal advice. I would also look to make sure I mean, you can always take a shot, see what the judge says, but take a look and make sure there's not an attorney's fees provision, because if there is and you lose, not only do you not get the property back, but you're going to be paying the other side's legal fees as well. So be careful.
Well,
I can't give you a specific legal advice, Vicki, because you know, I haven't read the contract and don't intend to.
Okay, and we do work with Todd at the firm which you once owned. So I will make sure to have him to review the lease again before we take the next step. But thank you.
Okay. You're welcome.
Thanks, John, for handling that. Thank you, Vicky. Sandy, you can go ahead and unmute and ask your question.
I already put in the chat, but I got disconnected a few times, so I'm not so sure it was answered. But if I'm selling a property that's tenant occupied and the tenant has a lease till August, and I get a couple of offers, and one of them is an investor that wants to purchase, is it biased if we go towards an investor contract, or do we have to play all of the contracts the same, because obviously the owner wants to help the tenant out?
Well, I'll take a stab at that. Try to figure out which law I'm pulling from right now, because there's 4 of them that, you know, are integrated. But here's the deal: if you're selling a house, and Branden, I know you guys have a lot of information about this, but if you're selling a house to a tenant, to a buyer who does not intend to occupy, number one, then probably the tenant gets to stay. There's a duty. First of all, you cannot remove the tenant till August under any circumstances because he's got a contract, number one, unless there's a clause in the contract that allows you to shorten the term under certain circumstances, you're stuck with August. Number two, because you're selling it to a tenant who does not, or a buyer who does not intend to occupy, you're under 1482, which is the rent control law, you're probably going to have to offer that tenant a new contract that is similar in nature to the old contract. What that means, of course, is going to be dependent upon the contract. So I'm not sure, again, I haven't seen any of the documents and I can't give you specific legal advice, but I'm not sure that even your investor is going to be able to move that tenant out of the property even come August if the tenant's willing to pay current fair market rent. So that's why you don't engage in property management right now, because these rules are so bloody complicated. You literally have 4 separate laws you got to figure out which to pull from. You've got standard unlawful detainer law. You've got 1482, which imposed all kinds of restrictions on rent increases and on just cause and relocation. You've got AB 3088, which put restrictions on evictions based on non-payment of rent and all those other criteria. And then you've got SB 91, which extended AB 38 and then added some additional language regarding use of deposits and things of that nature, and requires that you take certain action to go get some government money if it's available, and then you've got to file a declaration saying you did that. So good luck. Good luck.
John, and I also think that the new COVID relief bill had another extension in there for some of the rent stuff as well. I think till September 1st or September 30th. I'd have to pull it and check, but I know there was some extensions in the COVID relief bill as well.
And then you've got to deal with local jurisdictions, because I don't remember the number, Branden, but it's like 140 separate laws in California dealing with their own rules and their own restrictions. LA has one, and a lot of the Northern California stuff. We're sort of lucky out here that we don't have those things yet. We might someday. And then you've got the federal issues. Then you've got issues relating to fair housing. So again, good luck.
My question was the buyer that is non-owner occupied wants to keep the tenant. So if I have 2 offers, one is owner occupied and one is non-owner occupied that wants to keep the tenant, is it biased for me, for the seller to accept the one who wants to keep the tenant?
Well, Brent, I'll let you answer the fair housing implications of that question, but
I mean,
no, I don't think so.
No, I mean, there's no, not unless there's a protected basis implemented within this deal. I want to give it to this person because the investment group represents blank protected bases, and I want to do, because of the protected basis. Anytime you're talking about fair housing, if it's not because of a protected basis for making an action or doing something, then it's not triggering the Fair Housing Act, right? I mean, you're certainly right. There's a bias to, we want a corporation, it's a bias, but is it an unlawful one under fair housing law? It doesn't say that. Not unless, again, we're implementing a protected basis. For example, that corporation is linked to a protected basis and we want to favor them. Right now there could be more of an issue, or we don't like them, like the Ninth Circuit case on zoning and against the city of Yuma, where it was, hey, this developer builds a lot of homes, or it works with the Latino community. We don't want them here. We're not going to rezone the property for them. Stuff like that, where that's the real issue. If it's not the real issue, then it is what it is.
Then there was that travesty of a case up in Bakersfield where a new home development wouldn't sell one of their new homes simply because the person was a lawyer. I mean, and the court ruled in favor of the new home developer because the lawyer wasn't in any other group. He simply wasn't being sold the house because he was a lawyer. I know Branden and Jeff and I all think that's a travesty of justice, but the fact of the matter was, that was not in and of itself, at that time, maybe things have changed now, but at that time, that was not considered to be unlawful discrimination.
Well, I'll just add, I mean, as you bring it up, I mean, this goes to a deeper point under the Unruh Civil Rights Act, which deals with arbitrary discrimination. And arbitrary discrimination wasn't necessarily defined. There was a case, the Harris case, that gave factors for, what is arbitrary discrimination, right? Like what are, usually it's about a protected characteristic of somebody. I'm not gonna, sell my home to anyone with red hair. That's arbitrary discrimination about something you would know. And sometimes it can be extended to occupational discrimination, where that's a characteristic known. I'm not going to sell this home to a police officer. Now, it could be source of income too, right? I mean, so there's a lot of ways to look at that. So I would just caution, like, that the post-Harris case on arbitrary discrimination is quite broad, and it would get into some arbitrary factors if it's about a personal characteristic, as opposed to, I'm not going to sell my home to someone with a red car. It's not about a personal character. It's pretty bizarre, but.
Wait a minute, I have a red car.
Thanks, guys. We got questions coming through here. So let's move on to Andrew. You should be able to unmute and ask your question.
Good morning, everyone. Thank you all for your presentations. I appreciate it. I have two questions. I think these might both be directed to John. So I did a commercial real estate deal a couple years ago, and I was representing a buyer of a apartment complex. And when I submitted the offer, I did it on a CAR form, and then the agent for the seller represented a national real estate, commercial real estate firm. He told me that they could not use CAR forms, that I had to use their forms. Is that correct?
No, they can decide what forms you're going to be required to use. And so again, so long as they don't violate any other law, it's their property. They get to control how the offer comes in. Your problem, of course, is because you may be familiar with the CAR form, but you're not necessarily going to be familiar with this form. That's where you say to your buyer, probably should have your lawyer look over this form, because I'm a realtor. I have my own license to do certain things that does not include interpretation of contracts, and there may be things in this contract, and I can almost guarantee you there would be things in that contract that favor the seller and would hurt the buyer. So I'm just simply going to have to bring in someone someone of my profession to analyze that contract, and that's not untypical, even in residential.
So
yeah.
Okay, so thank you. So the seller can determine which form is used?
Yeah, again, so long as it's otherwise valid, it doesn't contain, invalid restrictions of any kind. Yeah, again, we do it all the time. It's called, you guys use forms, we don't. We negotiate contracts pretty much on the fly, and then obviously we have a lot of boilerplate stuff in our computer, but our contracts are put together on a transaction by transaction basis. So yeah, we use, language that's appropriate to our client, and that's what we fight about, is,
okay,
the language that's appropriate to our client. So
okay,
for you, if it's a form, because you're not a lawyer, you're not drafting these forms, you're using somebody else's. If it's it's not a form that you're familiar with, then you should get some outside advice. And that's not showing weakness. That's simply doing a service to your client. Again, particularly if it's a large apartment complex, that client's spending an awful lot of money. A couple $1,000s in attorney's fees to make sure the contract is correct is, not necessarily a bad way to spend money.
Okay, great, thank you. So my second question is geared more toward kind of a follow-up to the previous question. So as a broker, if I'm doing a real estate transaction for a client, can I tell that client, even before the transaction begins, that after the transaction closes, that I will donate a certain percentage of my commission to a charity? Is that legal? I know this is not really, you guys aren't giving me exact legal advice, but I've just a general question, is that something that I should ask, CAR Legal about?
again, I don't see any restriction on that. Again, you can donate your entire commission to a charity if it's a legitimate charity, sure. I mean, I don't see any problem with that. Again, all other things being equal, you know, if I say to you, if you say to me, you know, that you'll donate 10% of your commission to my church or to Salvation Army or something like that, a charity that I like, I don't put it in writing, because Article 9 of the Code of Ethics says all agreements shall be in writing. But other than that, no, I don't see there's a problem with that. Anybody, I don't know if anybody else does. I don't.
Okay, great. Thank you so much. I really appreciate it, guys.
All right, thank you.
Good to see you.
Cassandra, you are up next. You should be able to unmute and ask your question.
Hi there. So I'm mainly a listing agent, and as listing agents, we kind of have the upper hand on the buyer's agents because we get to see so many contracts. So right now there's licensed investors who are emailing listing agents saying, when you get my offer accepted, I will give you a bonus of $5,000. So these people, they're only seen if we report them. What kind of violations do these people get? Because they're licensed realtors. So how do we stop them from soliciting realtors to behave unethically, basically?
Are you concerned with the offer of the $5,000 bonus? Is that what you're concerned about?
No, I'm concerned with the wording. The wording says when my offer is accepting, so they kind of know that they're enticing you, saying, hey, listing agent, we know it's competitive out there, but we're willing to give you $5,000 or $10,000 when you get our offer accepted. And we'll even let you list it when we flip it. You know, things like that. Because these guys are sending that stuff out to listing agents, and I'm pretty sure some people are taking that offer, which is horrible.
Well, again, you're a fiduciary now to both sides, so you have a duty to disclose all material information, regardless of what it is. I don't know, Adam, it seems to me that there's, I think it's Article 4 or 5 or 6. There's an article that says you have to disclose all compensation of any source of any kind in writing to your client. So number one, you would, if you have a duty to present all offers objectively. So I got an offer and it says this. So I present it to my client. I say, here's their offer. This is what they're offering me as a bonus. I don't want it to induce you. I think the danger would be if I turned around, or if you turned around and tried to get your buyer or your seller to accept an offer without disclosing you're getting a compensation, maybe another listing, you know, et cetera, et cetera, et cetera. But in and of itself, and again, I can't comment on the writing because I don't have the writing, but in terms of the principle, I don't, you know, so long as you disclose everything properly to your client in writing, by presenting them with maybe even just give them the entirety of the deal. It's not confidential information, so I don't know that you couldn't do that.
John, that there's a potential MLS violation here.
Yeah.
Okay, because we have Rule 12.11 that limits the way you can use MLS information, right? So if they're getting this information from the MLS, that is outside the scope. What they're doing is outside of the scope.
Okay, that's a good point.
Of what MLS information can be used for. I mean, it kind of ventures into that territory of using the MLS, checking for expireds, and then calling on the expireds. That's not allowed. You're not allowed to use the MLS information for that. So now, if they're just finding this listing agent information like on your website and calling you directly, that's one way. But if there were to be evidence that, you know, they're conducting searches in the MLS for listing agents in their area, which we can find, by the way, we have record of searches, we could start an investigation on that. Now, if they specifically call you on a listing, right, that you've posted, and they say, hey, I saw your listing, take my offer, and you're getting an extra $5,000, there's no doubt in my mind that's an MLS violation. Because what you can only use the MLS information for is to just to market the property, the bona fide buyers and or represent your sellers, and or for evaluation purposes and appraisal, for appraisers, I should say. So depending on the
let's
facts.
assume that let's assume it's Cassandra's listing, and one of these guys are registered, he's a realtor, goes in, sees her listing, says, here's my offer. If it's accepted, I'll pay you $5,000. Well, everyone needs to disclose all that information, right? But from an MLS standpoint, I don't see where that would be a violation. It would be if he's mining expireds, that would be where the problem would come in, correct? In terms of MLS.
It's tricky, that you raise a good point in that if they want to make that part of their negotiation, if the offer is accepted, I'm not going to get involved in that. I'm just more concerned with misuse of, combing through the listings to do something like this again if it ventures into that, calling on expired type stuff.
And then of course the buyer would also have to disclose their status as a real estate licensee as well. And so again, that there's so many dots to hit and T's to cross that. But yeah, it could be done. It could be done correctly. And the $5,000 bonus, again, if Cassandra, for example, were to look at that offer though and say, I cannot recommend this offer to you, seller, for these reasons, then that, again, she's still got her fiduciary duty to her client, the seller, and if she undertakes to represent the buyer, she's going to do an agency disclosure form and all that kind of stuff. It's a lot going on there. She packed in a lot of, what do we call that in law school, guys? A racehorse question?
Well, it's just my understanding. It's my understanding that, we're held to a higher standard and that we're not supposed to take money like an appraiser. It's like me saying, hey, Mr. Appraiser, if you come in at value, hey, I'll give you an extra.
Oh, no, that's a whole
$10,000.
different issue.
Oh, exactly. So I thought that we were held to a standard where we are not allowed to look at that money and say, okay, you know what, I'll do that. I'll go ahead and take the $5,000 and I'll have the upper hand of everybody.
But you're not the
what
one.
Would be the difference though between saying, well, Jeff's only offering 1.5%. I'm not going to show that house because it's not enough money. I don't think that's the issue. I think the issue is your fiduciary duty and how to properly discharge it. If Jeff's saying, hey, if you take my offer, I'll give you $5,000. Well, obviously what he's trying to buy is Cassandra's integrity, possibly, and if that could be where the problem is. But you have to look at it from an objective standpoint. If his offer is otherwise fair and reasonable, then and Cassandra discloses it to the seller, I'm not sure that in and of itself would be a violation. Non-disclosure, yeah, you got $5,000, put it in your pocket, never told your seller you got the $5,000. There's a case called Roberts versus Lamonto, where you're probably, I love this word, you're going to disgorge your profit to that seller.
It's called self-dealing.
So it just depends on how you do it. There's usually a right way and a wrong way to do everything. And,
John,
I
was just going to say that, John, when I heard the question, that was more what I would, up until that point, you were assuming that everything was fully being disclosed. I think the way I interpreted her presentation was that money being used to sway my offer, that particular offer, to be presented in a stronger light than the others, which then, would be a violation.
And I agree with Barbara Horan. I don't like it because, good luck persuading the jury that you did everything you were supposed to do, and you didn't, particularly if you have multiple offers, and you were trying to persuade the seller to take that offer. But again, to say point blank you can't ever do it, I can't do that.
Yeah,
there would be ways to do it, but
God forbid.
I don't disagree with Barbara that I don't like it.
God forbid something happens. God forbid something goes wrong with that deal if they accept it, right? Because now your seller's going to have a problem with you,
that goes to the heart of dual agency, is that, I just sold my house, as some of you know, and if it was a dual agency situation, there were times, when you accept an offer, that's the prenuptial agreement, right? Everybody's in love, right? But then all of a sudden, let's say things go wrong during escrow, right? Now, whose side do you take? That to me is one of the core problems from a risk management perspective with dual agency. It could be a fair housing issue that crops up. It could be any number of issues that crop up. Now all of a sudden I'm equally representing. It's the reason that you and I and the three of us can't represent the same side, right? There's inherent conflicts that could come up that might not exist on day one, and that's where you get into your difficulty. I think.
Thanks, John. Cassandra, great dialogue, great question. We've got two hands that have been raised for quite a bit, and I'd like to try to make sure we get to both of them before we hit 12 o'clock. So let's go ahead and move on to Elena. You should be able to unmute.
Thank you for taking my question. I wanted to ask, what inspired the California Consumer Privacy Act advisory form? I believe that took effect this year. And also, is it a mandatory form that both buyer and seller need to sign?
Not mandatory. It's part of your package now, and you should get it signed. I don't recall that the form itself is risen to the status of the TDS. Maybe Jeff knows or Branden. I don't think it's a mandatory form, but there's lots of things that are not mandatory that you should do, because if it gets to a jury and you didn't, you're going to be in trouble. I think that's why C.A.R, if I'm not mistaken, I'm not a realtor, but my understanding, isn't it part of your package now? Isn't it part of what's bundled? So
yes.
Is that the right word, Adam? Did I use the right word?
Yeah.
In a technical. So I don't think it's mandatory, but I think you should use it. And C.A.R worked very, very hard to create that form.
Thank you.
Okay, and is it Ancoma? You should be able to unmute and ask your question.
Thank you. So it's funny, somebody posted this just now on Facebook, and I think they're down from San Diego, but the question was, is it illegal or legal if another agent calls you and asks what your highest offer price is? Like, you get multiple offers. As a listing agent, can I disclose the actual price of the offers that I receive?
If your seller's giving you consent, you can.
Okay.
It's part of Article 3. If you're my listing agent and I've given you the authority to disclose information about competing offers, it's actually in the competing. What's the name of that form? It's the it's the disclosure of potential competing interest form, the CBR, I think it is. It actually says that in there, that your offers are not going to necessarily be confidential. So if I call you and say, what's your best offer? And your seller has given you that authority, you tell me, $700,000, and next thing I know, I'm making an offer at $720,000. And frankly, what is one of your primary fiduciary duties? To get the highest and best offer you possibly can for your client, right?
Perfect. So, thank you so much.
My pleasure.
All right,
nice background, by the way.
Yeah. So we actually, if there's one more question, we can probably get to that. I won't put anybody on the spot. If not, if no hands are being raised, I will once again just want to thank our panel so much for their time this morning. It's not often that we get a chance to hear from three lawyers like this and kind of ask questions away. So we definitely appreciate that. Oh, looks like a hand. Oh, Cassandra raised her hand again.
I know, sorry. I've been doing this a long time, almost 20 years. So I put it in the chat, but are sellers or landlords able to discriminate against sex offenders?
Yeah, I'll take that. I mean, look, I can't speak to like whatever release someone may be if they're what they call the 290 sex offenders. They may have certain restrictions, but on its face, I mean, what the California Fair Housing Regulations are saying is they're saying, look, you can't blanket ban everyone, no matter when it happened, no matter what it was. just like, but if you look at our material that I'll try to send out here in a second in the chat, it really walks through this kind of analysis, saying like, okay, you ran their background check, you see an offense. Is that offense directly related conviction to your interest of having an apartment complex that's safe to the residents and others? Yes, it is. If someone was convicted. Now, what was the conviction? Oh, it was a very serious sex offense that was, conducted, that happened recently. Those are all going to be factors that err on the side of, this is a conviction I'm concerned about. Now, just suppose that, say it was 5 years ago, 50 years ago. The person was 18. The nature of it was, someone submitted some information about maybe the nature of it, what happened. It was an 18, 17-year-old thing. Not, it was consensual. I'm just throwing all this stuff out there to show that you can't just say, never in a million years will this type of conviction live in my property. You have to go through the analysis. So you can't make the discriminatory statement, right? You can't come out, right there's a violation, say, I'll never rent to anyone with a felony or these types of felonies. You have to go through that consideration, but oftentimes it may end up on that side when you go through the analysis. But I would say the longer the time goes, the nature of the offense, what was it? Well, not every sexual offense is the same. Some are very violent, some may not have had some of the elements of violence, right? So it's hard to say, but no, you can't blanket ban everyone. Yes, you can exclude people if their criminal history is directly related to your interest as having a safe place. But you got to go through that analysis. You can't blanket ban. And we have guidance for you at the DFEH website. Just go to the publications tab. We have an FAQ that walks a property manager. And even I tell sellers, you should know this because you're running into this now with HOAs, what the rules are if they're trying to exclude someone. Say, you got a felony, you can't live here. Well, that's not the case, and that could end up being a violation. So yeah. So look to the answer. So the short answer is yes, people can be excluded for certain felonies, but you got to go through the analysis and not blanket that.
Perfect. Thank you.
Cassandra, thanks again for the question. Branden, thank you. And that is going to just about wrap us up. So once again, John, Branden, and Jeff, thank you so much for your time. Seen a couple of comments come over the chat that everyone's really enjoyed. Not only all the information that's shared, but the different perspective, from each area of expertise. So maybe this is something that we can look to continue to do in the future. We also do, I believe they're quarterly, John, if I'm not mistaken, brown bag legal updates with John G as well. If you guys haven't attended those, very similar to this, John likes to keep things interactive and applicable to what's out in our everyday life. So I encourage you to check that out. Our next one is scheduled for Tuesday, May 4th from 11:30 to 1. And I believe you can just contact the association to get registered for that if you don't have that already on your calendar. But again, to our panel, if I give you maybe a virtual thank you, round of applause, we really appreciate your time. Anyone have any closing statements or anything that they want to say before we adjourn?
I just want to thank first of all, you, Adam. This is the first time you've done this, and you did a phenomenal job. We've been doing this panel type procedure, both Jeff and I and Branden at another board, and you did. So we have something to compare it to. You did a phenomenal job moderating. Thank you. And to Branden, always willing to help. Always willing to step in, and of course Jeff, this time is always valuable, and he's always willing to share. So as the lawyer who was asked to put this together, I'm incredibly grateful to those two guys, and to the people that are still out there. If there's someone mentioned that different lawyers from different fields, if there's a field that you would like us to cover, the good news about being in business for as long as I have is I know who the best lawyers are, and I'll go call them. I did that with Branden. I did that with Jeff. I'll go call them, and we'll get somebody in here on whatever topic you think, whether it's risk management, liability, estate planning, you name it. We'll get somebody in here, and we'll do another panel whenever the board tells me they want that to be done. I like this procedure because you get people like Branden who, just such a wealth of information, just a great way to do this. I really, really appreciate being able to do it.
No,
That's all I got.
Thank you too to everyone. Thank you, John. Thank you, Adam. Thank all the members. It's always a pleasure. And just know that here at DFH, we're always here to help. If you need information, need resources, I know we all have the same mission in mind of having a California that's fair for everybody. So, so thank you and have a great weekend. I appreciate being invited.
I appreciate you
Thank
guys
you.
too.
Thanks,
John, John's always a pleasure to sit beside you, even if I'm far away from you. Just from our perspective, I would say just stay tuned, stay tuned in. I commend every person who stood, attended this. It can seem a little dry, but, good for you. You're going to be you have a leg up on your peers, by being informed. And on that note, please make sure you take the time to pay attention to the pop-ups that come through when you log into your MLS. Pay attention to the emails that Association Resources sends to you. There's going to be a lot of things going on this year, just like there always are. And so if you're the person who's paying attention, you'll have the benefit of being that much more professional and prepared than your colleagues.
Thanks, Jeff. And for those that are still on, this has been recorded and it will be posted to our Facebook page probably by Monday, I would assume. Daniel, you give me maybe thumbs up, maybe early next week, but it will be posted. So if you want to refer back to any of the information that was shared, you can find that again on our Facebook page. So thanks to everyone. One more time to Daniel, congratulations on your 15 years with the association. We appreciate that. And to our panelists, thank you once again. We will go ahead and adjourn out our meeting. I wish everyone a very happy and safe weekend. Go sell some real estate. We'll talk to you guys soon.